my microphone, so I'm going to start over, okay? Start over fresh and new. How's that? Good morning, everybody. So today is July the 16th, 2022, and welcome to my channel. We have been talking about Nikolas Cruz, the 19-year-old, 19-year-old at the time, um, who killed 17 people and injured an additional 17 in Florida in 2018 on Valentine's Day at the Marjorie Stoneman Douglas High School. Currently, they are in the motions phase of this so-called trial. Opening statements are Monday, July the 18th. This has been a very long time coming. It has been. They have set a date, and then move the date, and set a date and move the date, set a date, move the date, set a date, move the date. It's been crazy. It's been, if you followed it, it's been worse than the Lori Vallow Chad Daybell case. Truly worse. I think one reason for the nature of not ever seeming to get to the roadblocks. Let me say it this way: the roadblocks that had been placed every time this judge, Elizabeth Shearer, every time Judge Shearer has mapped out and planned a calendar, then the defense attorney has, thrown a shoe into the whole proceeding and disrupted it. So it looks like at this point now, she has had enough. Like, she is absolutely done with the defense attorneys. There are 5 attorneys on the defense side. There are 5 attorneys on the prosecutor side. And we have 2 witnesses with their own attorney, which I find very interesting. They're coming from Virginia. And part of me wonders if it's that young man who has been caught multiple times in lies about whether or not he was actually at the school on the day of the shooting. He claimed he was, but then later there was video that came out that showed that actually he wasn't even at school that day, and that after the shooting he got his camera and went into the school and did, tried to pretend, I guess, like he was, there. So it's very confusing. But we'll see. Anyway, the point being is we're here. Now, this judge, Elizabeth Shearer, she really and truly has had enough of the defense games. She's had enough. And that was evident back in the first part of it was a hearing that was done the end of June, I think June 29th. They were having, obviously, another argument, the defense asking for another delay. Defense never can get their witnesses there. Their experts can't get there. The attorneys can't get there. There's always some problem, and it's just been pushed down. And Shearer has finally reached a point. Here's kind of what that spirited exchange sounded like. Shearer said, well, they could have brought it up. The state says, it's not fair. It's not fair. You said we were pending a ruling. It's not fair. And of course, then the prosecution stands up in a very rational manner and says, well, true, actually, Judge, this is what happened. She agreed. And so she says, well, they could have brought it up. And then she finally put her hands up. She looked at, she said, lawyers from both sides, and looked deadly, like, hard at the defense. She said, stop talking. We are in recess. And she got up, left the stand. So she's had enough. She's pretty tough. A lot of people don't like her. She is very young, and she is very beautiful. She's sort of your made for TV judge. She could also be a Dallas Cowboys cheerleader. So, it's interesting, right? Interesting by way that the stereotypes go for some things. So she is very beautiful. Her makeup, may I say, is on point, impeccable every day that I've watched one of these hearings. Um, Let's see. Before we start today's motion, a couple of things. Oh, the nature of this case, the defense's job to try and get the jury to see this kid as a human being after what they're going to hear. They're going to hear and see the deaths of 17 people, 14 kids, all of them accomplished, just the kid that's sitting in your house today that you love dearly. That's the faces of these kids that were killed. And then there were 3 adults, not to mention the 17 that were injured. And so jury selection, as you can imagine, was quite difficult. They had a very difficult time. In fact, at one point, they had seated several jurors, and one afternoon, 2 of them said, wait, I got to tell y'all, I have to be honest. Previously, my opinion was that, I could sit here and I could judge someone and I could have them, put to death. I did do that, but I got to be honest with you. I would be lying to the court and I would be lying to myself if I told you that I could be fair and impartial. In this case, the severity of what happened and the number of lives that were altered, I am not going to be able to be fair. He literally interrupted the court proceedings to tell them, hey, I know you got me on this jury. I can't do this. I know right now I would vote him guilty right now without hearing anything other than what I saw that day. There was a second guy that had a similar type of really emotional reaction, but it was from the other part of the aisle. His was fairly political. Now, this is after they were seated, you guys, like after they had gone through all the questioning and they were going to be on the jury. I guess he took the opportunity after the first guy said, I would, because this case is so severe and so many young people were killed, I can't be fair, right? I don't know if this guy then reacted to the first, but the second guy comes up and he says, I got to tell you, he said, my opinion is, and this is a direct quote, my opinion is I don't see myself ever voting for somebody sitting over there getting a life sentence. What really confuses me is that it only takes one person to give him a life sentence, but it takes 12 of us to give him a death. So he was making reference to the 12-member jury must be unanimous. So then I got confused because I had just read an article saying, well, wait a minute. What about the flip-flop from the Florida Supreme Court, unanimous jury on death penalty versus not unanimous? And we all, as this trial begins on July the 18th, Monday, the jury, it must be unanimous. And it is confusing because they did flip-flop on their choices on how they wanted to read the law for death penalty cases and jury determination. But at this point, as this jury goes, they have to be unanimous. Now then, I wanted to. Oh, another stunt by the defense. I mean, these defense attorneys, this is going to be a hell of a trial. This is going to be a hell of a trial if for no other reason than the shenanigans of the defense. Truly. So at one point, they were interviewing, they were still interviewing potential jurors. And one of the defense attorneys got up and I think his name is David Wheeler. He said, again, a direct quote, he said, "I don't know about you," talking to all the potential jurors that were in the room that day. "I don't know about you, but this case is giving me PTSD." Well, obviously the prosecutor jumped out of his shoes to scream objection, and he threw a 9-line fit and said, "This is highly inappropriate thing to say to the jury on every level." I mean, he pretty well, ranted for a bit. He was furious. And so they did, obviously have a sidebar, do the whole, "I hate you, you're the defense. Well, I hate you more because you're the prosecution." And ultimately the judge did tell the jurors and potential jurors, you have to disregard anything related to PTSD. PTSD is not a part of this case on any level. And the attorneys definitely spoke out of turn and should not have said what they had said. I think the reason that they were, the reason that he was talking, I think the reason that he made that comment about, "I don't know about you, but this case is giving me PTSD," which is also not only was it inflammatory, but isn't it a bit demeaning to the kids that lived through it, the teachers that were there trying to protect the kids? Isn't that, do you know how many people ended up with PTSD that day? And for this guy to make this sort of flippant kind of, smart alecky little comment, it was just really odd. And the defense it's a strange team. And I only say they're strange simply because of the antics that they've engaged in to keep putting this ultimate day of reckoning, further down the road. Push it. So now it's here. They're done. And Elizabeth, Judge Scherer has made it clear she's done. She doesn't care anymore about their antics and their stupid games. So they have, okay. And then, so Melissa McNeil, who's part of the defense team, who creates a great deal of drama and distraction, she has perpetual resting bitch face. I mean, she's in a bad mood all the time, and I don't know if it's because of this case or if it's her personality, but she's not anyway. So they get their 12 jurors. They have 12 jurors, 10 alternates. Everybody's happy. Everybody feels like things are good, right? And public defender Melissa McNeil stands up and says, "Judge, we are not accepting this panel, blah, blah, blah." And the judge said, "Tough titty. We're moving forward. Sorry, but you've had you've been allowed so much time. We have given you so much room to postpone, and we're doing this no longer." Ultimately, there are, of the 12 jurors, there are 7 men, 5 women. They include a probation officer, an immigration officer who was in the U.S. military, a financial executive who served with the French military, the son of a police officer, and the daughter of a former police chief. There's a legal assistant, a librarian, a computer technician, a stocks supervisor at Walmart, a medical claims adjuster, a human resources executive, and a music lover who works in a family business. So I think without question, they have chosen a jury from every strata of life in Florida. If this is not a jury of his peers, I don't know what is, right? So I don't know what Melissa McNeil was freaking out about. Even though she jumped up and screamed she wasn't going to accept the jury as it stood, Broward Judge Elizabeth Scherer swore them in, and she said that the attorneys must be prepared to deliver opening statements on July the 18th. She's not going backwards at all. And of course, Tom and Gina Hoyer, which is Luke Hoyer's parents, they were there to watch all the shenanigans. Okay, so they've been very committed. I mean, not that any of the other families were not committed; they were, but she's obviously still feeling quite connected to her son, and trying to be protective of him. Now, you should be seeing, I have not been watching the chat, but you are. Okay, so that's where I would move to this. There you go. Okay, so hold on 1 minute. I'm trying to find my place now. There was a 17-year-old, Joaquin Oliver, who was shot 4 times. There were 7 14-year-old students, and the 14-year-old students were Elena Petty, Alex Schachter, Alyssa Al-Hadef, Kara Loughran, Gina Montalto, Jamie Gutenberg, and Martin Duke. And then 2 15-year-old boys, which were Peter Wang and Luke Hoyer. There was 16-year-old Carmen Shintrup, 17-year-old Nicholas Doret, and 17-year-old Helena Ramsey. And then the oldest was the 18-year-old senior Meadow Pollock. And her family has been very active politically since all this happened. A lot of these families, these kids have become quite political. Cruz also killed 3 adults, 3 school employees, Scott Bagel, who was the cross-country coach and geography teacher, Aaron Fees, who was an assistant football coach and a security monitor, and Chris Hickson, who was an athletic director and wrestling coach. And they were very brave people, literally putting their bodies in between the killer and the students. They were incredibly brave. Okay. Okay, so they're going to show premeditation by the planning on postings on social media. They're going to show his propensity for violence, using his attraction with skinhead kind of white supremacy, swastikas, cruelty to animals, racism, misogynism, tendencies toward pedophilia, rape. So this kid, needless to say, why he was not somehow being monitored. Monitored by the state. It's very difficult to say. And a lot of that is nobody wants to look at a kid and think that a kid and harm another person. Nobody wants to think that kids come into the world evil or bad. In this particular case, it's even hard. Look, okay, so Nikolas Cruz is adopted, and he was a baby when he was adopted. He was not very old. He was adopted with his biological brother Zachary, and he was adopted by Linda and Roger Cruz. And for all intent purposes, from the outside looking in, it really does look like the two boys had a really great life growing up, that they had two loving parents. They grew up in an upper middle class family. There was plenty of money, but it all fell apart rather quickly. It fell apart quickly. It's interesting. It's almost like a tale of two brothers, because Zachary, even though he's the biological brother to Nikolas, he's doing great, makes great grades. He's in college. Well, I think he's graduated college now. But Nikolas was odd, and he was different, and he couldn't connect to people. People stayed away from him. They felt very uncomfortable in his presence. Even teachers talked about noticeably trying to move away from him, because they could feel this energy that he put off. It's interesting in a lot of ways. We heard the same thing about Chris Watts. You think about it, Chris Watts was a really attractive young man when he was in high school, but he just couldn't connect with people. He just couldn't. He had two friends. They remained his friends throughout his lifetime, but he never made any real friends other than that. They were all quite shallow and superficial. Hey, good buddy, how you doing? But nothing, no real connection, no commitment to one another. Now, the hearing that we're going to listen to today, give me 1 minute. I'm dealing with a terrible cold, so hold on 1 minute. Okay, sorry. All right. The hearing we're going to hear today, I've kind of fast forwarded through a lot of the arguing part of it. Not to doesn't mean they're not gonna argue, because they do. They're rather great arguers. This is a fairly unusual courtroom. The personalities that are in the courtroom, it's interesting. It's there, and you got to assume that it's the nature. You got to assume that it's the nature of the crime, right? It's such a horrific nightmare that all of these people were assassinated and killed by this person that absolutely should have been monitored by the state. He had been involved in so many things related to animal cruelty, and he had guns. He was buying guns left and right, despite this history of real violence and impulsive, violent attacks on others. It's just mind-boggling. It's mind-boggling that he wasn't being watched and monitored. But so his team look at him as, a kid, a young person, a young man with, intellectual disability or developmental delays. And the state is coming back and saying, you know what? You can go ahead and try to turn this into something that it's not. The fact of the matter is, we have the testing from throughout his school career, and his adaptive functioning did not suggest that he, had serious developmental delays. He's got some fetal alcohol syndrome genetic testing, but regardless, he does know right from wrong. He did know how to go in and purchase a weapon legally. He did sit down and plot and plan and physically train to do these horrible things. So while you're trying to paint this picture of this poor little boy who just didn't know any better, trying to make people, feel sorry for him, We're over here looking at people like Luke and Gina Hoyer. I'm sorry. Mr. and Ms. Hoyer sitting in the courtroom every single day throughout every minute of every motion, representing the families of all of these people that have been murdered. So no, sell your bleeding heart tears on down the river here. We don't care about this guy. He is a killer from the word go, and he should be locked away from humanity forever. Or better yet, let's just remove him from the face of the earth before he hurts someone else. He's been in jail for 4 years. And how many times has he tried to choke and kill prison guards? Well, not prison guards, but jail guards. I mean, something wrong with him. Well, there's a lot wrong with him. And so, no, there's not, at this point, after all these years of investigation and study of this kid's life, they have learned that there are no redeeming qualities to this young man. None. Like, this guy makes Jodi Arias look like Queen of the Prom. He's a bad guy. He's quite animalistic, a little bit like a shark, in my opinion. Sort of just a killing machine. He's just alive. He eats food, he drinks water, and then if he gets mad, he hurts whatever's in his way. There's no emotional connection to anything. It's fairly chilling that he was out walking around with no supervision at all. All right, I'm going to keep my mouth shut. We're going to move forward. Again, these are motions in preparation for opening statements. The trial begins Monday, July the 18th. I work. Y'all know that. I don't know if I have COVID or not, but I am sick. So I'm hoping that some of you guys will make sure that you can try to watch the trial, like every bit of it, and maybe give me a heads up on stuff that I have to cover each night. Because I do work. So, okay, here we go.
So we just want to prevent the state from asking those questions in this situation. Maybe they don't intend to do that, but because of the deposition, we wanted to bring to the court's attention because this witness is very sick. And we don't want to delay the perpetuation of her testimony. Okay.
Judge, let me apologize in advance. This is going to be a bit of a lengthy argument.
Okay.
So, Your Honor, the defense motion in limine seeks to eliminate portions of the cross-examination of Finney Brow. Now, the defense argues in their motion that in the deposition, the state, and this is at page 6 of their motion, quote, administered the Vineland test to Miss Brown. They stated that.
You're not on the motion to determine confidentiality. Now
No.
You're on the motion to eliminate.
Yes.
Okay, page 6, you said.
Page 6, and it was.
Okay, let me interrupt very quickly so that you'll have context for what they're currently talking about. So you remember when I talked about earlier, when I made the statement that the defense is trying to paint this picture, or their plan for the jury is that they're going to paint this picture of Nikolas Cruz as a young man who had lost both of his parents, who had lost his whole foundation, and he had an intellectual disability, that he was developmentally delayed, that he was the victim of fetal alcohol syndrome. Well, the prosecution has all the testing because he was in special education from elementary all the way to the day he graduated. So they have just a treasure trove of testing. I'm talking about good objective, projective, that great testing all the way across the board. They're about to talk about the results of the Vineland 3. And the Vineland 3 is a test of adaptive functioning. You give this test, it is the flagship assessment for level of adaptive functioning. Just 1 minute. Okay, that you give this test to assess for deficits in adaptive functioning. And adaptive behavior would cover skills that might be related to communication, the social skills, whether the kid has the ability to interact effectively with others. Does he understand or comply with like social rules and what would be considered appropriate public behavior? Personal, it also tests for personal independent behavior, both in the home and in the community. Both in the home and community, and then also in relation to school or work functioning. So the Vineland is the flagship. It's the test of choice in these types of diagnoses. If you're diagnosing for a determination for intellectual disability, the Vineland 3 is part of your testing protocol. So you want a test of intellectual ability, which is traditionally would be the Wechsler for children, the WISC. You'd have the test for intellectual, what is their IQ. You would have a test for their achievement level. And then for sure you would want the Vineland for adaptive functioning. There's also the ABAS. There are other tests besides the Vineland, but it's sort of the number one go-to. It's the standard. And then to back up your Vineland, I always give BASC for home and school and self. So they know this kid. The prosecution knows this kid. The amount of testing, the amount of information that would have come from his school career in special education, they know him. So the defense doesn't want the jury to know that, he was his IQ is a little bit low. Adaptively, he could communicate properly. He had independence at home and in the community. He suffered social skills. And I believe it's going to show that he had work functioning, school functioning deficits. But I think his communication and his personal independence in the home and community, I think those are going to stand. It's going to make it very difficult. Even if his IQ is at 70, if his IQ is somewhere between 68 and 75, but his adaptive functioning is higher, they're going to have a really hard time making the case of, he just didn't know any better. He just had these emotions and he didn't know how to manage them, and so he acted out. He didn't know it was wrong to shoot and kill 34 people. They're going to have a difficult time making that case with the testing that was done. You can get your IQ score. Got to note this. It's important. You can get your IQ score. If it's somewhere in the 68, 75 range, though, you're going to defer. The school will defer to the level of adaptive functioning for a final determination of, it's this kid who needs those skills. Is there a determination of intellectual disability or not? That is the educational designation is dramatically different than a medical diagnosis, say, that I would make in a clinical setting. I'm going to follow the DSM. In a clinical setting, I'm going to follow the diagnostic criteria for that is established in the DSM and DSM-5, and we're gonna follow basically a mathematical equation. We're going to do all the same test, and then we're going to look for 2 standard deviations below what would be considered age appropriate, right? Or that his achievement is 2 standard deviations below what his measured IQ is. Same thing with adaptive functioning. I want to know, is his independent behavior is at 2 standard deviations lower than what would be expected given his age, right? So, but that's a much different final determination than what the school system is going through, what an educational diagnostician would do, because they're not really diagnosing these conditions. What they're doing is they are providing a determination for services, which is, I know it sounds very simple. It's hard to kind of parse it out, but when it comes to things like insurance versus money, educational money allocation, those are very real differences. Those are clear, So in school, they are assessing for determination for services, DID. Okay. Clinically, you're looking at a medical diagnosis for treatment or institutional behavior assignment or something like that. Okay, so I want to go through that. So when they're talking, you're gonna understand what they're talking about when you hear them talk about the Vineland 3. It's a test for a test for level of adaptive functioning or for adaptive behavior, however you want to say it. I am very sorry. My voice is so scratchy. I know it is. I'm sorry.
You'll see that in paragraph 11. That it was me, Your Honor, who took the deposition. So if it's not clear, I guess it is clear in here that it was me. That I am not qualified to administer the Vineland 3 because I'm not a licensed psychologist, and that the manner in which these questions were asked was inconsistent with the appropriate administration of the Vineland 3. The defense goes on to say that they are fearful that the questions and answers would be inappropriately relied upon by state experts in forming their opinions. They say because the deposition transcripts are public, I have compromised the entire integrity and security of the Vineland 3. Now, just for the record, I never mentioned in the deposition the Vineland 3. There was a point in the deposition, as I recall, and I'm sure Ms. Curtis remembers this, and if she remembers it differently, that would be fine if she remembers it, if she wants to correct me. That as I was asking some of the questions, and I believe at the time the defense did not have the raw data. I think their position was that they don't want the raw data. And then I was asking questions that she didn't understand the relevance, and we went off the record. And in fact, we had a phone call, so it wasn't something that anyone could hear on a Zoom call. And it was at that point that I made Ms. Curtis aware that if she had gotten the raw data, she would understand the questions that were being asked of the witness. So for the record, again, the state never mentioned the Vineland, and if the defense was so concerned about the publishing rights of a company that has virtually nothing to do with this case. This is a death penalty case. This is a penalty phase. I don't think it's genuine that they're concerned with the publishing rights of a company that is forced to give up these raw data because there's a court order that says it has to be. Of course, it wasn't them directly, but the experts themselves. It's a court order that causes this data to get to the state and to the experts. I do want to clarify something.
And just let me explain. The defense is saying, oh, but this is a copyrighted test. You know, we can't have this copyrighted test go up, you know, as evidence in a trial that will be later released, and everybody's going to see the testing protocol, right? The actual test form that you circle, you know, the number of how well or how often you observe this behavior, or the person engages in this behavior. They're saying, the defense is saying, you know, we object to this information coming in because the only way it can come in is if you show the protocol. You can't show the protocol because that protocol is a copyrighted document. I'm sorry. Did you guys hear what I said a while ago? The Vineland has been used in forensic psychology for eons. It is the standard bearer for establishing a level of adaptive behavior. If anyone was going to make this argument, I would think it would be Pearson Publishing. They're the people that print the test, and that's who you have to purchase it from. It's an expensive test too. It's highly lucrative for Pearson to keep this test, you know, safe. Now, it's odd to me. It's so bizarre to me that this defense team is using this as an argument because it's a test that is so common. I think every person in prison has taken it probably at least 5 times. It's not the Vineland 3 is a test of adaptive behavior. You know, when you were 3, could you brush your teeth independently? 0 times, right? Not 5 times, 0. When you were 10, could you brush your teeth independently? When you were 12, were you brushing your teeth independently? Can you hop on 1 foot? Can you throw a ball? I mean, these are not secret, highly, you know, empirically derived items on a test like you have, like with a whisk. These are, or not the whisk, but the MMPI. These are, it's a accounting of expected human behavior that should emerge at a given age. And it's extensive. It takes a long time to give these things. So it's not secret to say that on the Vineland, they ask, at what age was this person able to hop on 1 foot? It's not secret. It's can you walk upstairs using alternating feet? Those are the types of items that are on one portion. There's other portion like communication and whatnot. But anyway, this is such a bizarre argument for the defense to make. But again, they have to try anything that they can because they don't want the information coming in. They don't want, it's not going to go, it goes directly against what their narrative is going to be. Their narrative, I believe, my opinion, their narrative is going to be, he didn't know better. He was without parent. He had lost all his family and he graduated from school. So there was no kind of environmental supports, the things that are required for somebody with an intellectual disability. He had none of those things. And that's why he did this, because he didn't know how to respond to negative emotion. That is going to be that's going to be their narrative. I believe it in my heart. And the problem is that the prosecutors are sitting on a treasure trove of testing by educational diagnosticians from throughout his school career. They will even have his early preschool testing. So I get why they have to make the argument, but it's silly. It's a silly argument in truth.
That Mr. Secor said is in his remarks earlier, he said that it was turned over to the state's experts. And it wasn't turned over to the state's experts. It was turned over to the state attorney's office. And the order makes it clear it was turned over to the state's experts, excuse me, to the state attorney's office. And the state then turned it over to the experts. There was no indication that the state attorney's office was not going to get possession of the raw data. It is a matter, psychologists don't have special dispensation from the courts. If it was an MRI, we would get an MRI and we could question a doctor about an MRI. There's no confidentiality.
Exactly
about
right.
an MRI. It's no longer confidential when it's been turned over to the opposing party and its experts. We can ask any questions that are deemed appropriate. And of course, because we're not psychologists and we may not be radiologists, of course, we consult with our experts. Now, the defense attached an affidavit as defense has stated by a Dr. Saulnier. Is that how you pronounce his name? Saulnier? And they,
Sommelier.
I mean, which motion?
I'm only addressing the motion in limine
Is that
14.
I don't,
The Vineland was written, developed by Sparrow
I'm
I
and
believe it's a
Summerly.
3-page document.
I have a 7-page motion and eliminate DMIL 14. But I don't have an attachment to that. Is that something I can get off the,
You should be able to, Judge, but I have a copy of the affidavit. I'm just trying to find out the number of these.
I don't have any attachments to that particular document, so
Okay.
if there are multiple exhibits, I can go on the CMS and print them.
It's Exhibit G. It's a 3-page.
May I
Doc.
approach you on it?
Sure.
It's like 268 pages
Maybe that's
of
why.
exhibits. Some of them are depositions. But this is.
Is this for me to keep or do I need to?
No,
give it
you
back?
can keep that one.
Let me just pull up the document on the,
That's exhibit G, Your Honor, affidavit from the file.
And again, these are motion, this is a motion hearing, so it's not exciting, but
I don't need the attachment.
occasionally they
On the computer.
are discussing something that's, of interest.
All right, good.
It's a second exhibit.
Hi, Rabbit Dog. Hi, Antimony.
All right, let me just pull up the document. Okay.
The trial for the penalty phase for this killer here, who is Nikolas Cruz, and he has pled guilty to the murders of 17 people at Marjorie Stoneman Douglas. It starts Monday, July the 18th.
Quote I was going to read anyway.
Okay, go ahead.
There's a quote from I would like to quote Dr. Saulnier as well as the defense did. They did in paragraph 16 on page 8 of the motion in limine, where she said that the deposition of Ms. Browd is not a reliable or valid assessment of Mr. Cruz's adaptive functioning because the questions asked were not asked in a manner consistent with the Vineland 3's manual instructions for standardized administration of the instrument, nor were the questions asked by a qualified examiner. Therefore, no quantifiable or interpretable data can be generated from her answers. And said
Not
the
true.
Deposition of Ms. Browd, in my opinion, is not a suitable substitute for and does not validate the Vineland results collected by Dr. Brown. First of all, in terms of this affidavit, the state is going to move to strike the affidavit.
Thank you, Antimony.
And affidavits are not admissible to prove facts in issue at a hearing because they are not subject to cross-examination and because they impermissibly shift the burden of proof to the party. I would cite to the court two cases, Fortune versus State, 611, Southern 3rd, 441, a second DCA opinion from 2011, I have a copy for the.
Hey,
board.
critters, welcome. Rabbit, he was 19 when he committed the shooting. That was in 2018 on Valentine's Day, 2018. So he's 23 now.
And a second case, it's for the same purpose, that an affidavit.
Hi,
not
critters.
admissible to prove
I hope you're
facts
doing good
issued
today.
at an evidentiary hearing. It's not, because
Thank
it's
you,
not
Nancy.
subject to cross-examination. I'm going to properly shift the burden of proof to the adverse party, and that is Doug Sears, SEARS Consulting, Inc. versus ATS Services, Inc. at 752 Southern 2nd, 668. It is a first DCA opinion 2000.
And again, the reason why we're covering this is because the trial starts on Monday. Opening statements will be Monday.
Dr. Solinger is not here to be cross-examined as to what information she had, what she was given. It is completely useless to the court what Ms. Solinger says in affidavit, because it's not subject to cross-examination. And we will move to strike that affidavit. Your Honor, it would be appropriate at this point to go to the law is concerning raw data and testing information. And as the court appropriately granted the state's motion for the raw data, the court at that time relied on the Florida Supreme Court decision of Abdul, ABDOOL versus State, 53 Southern 3rd, 208, Florida Supreme Court case in 2010, as well as Bailey versus State, 100 Southern 3rd, 213. It is a 2012 decision from the 3rd District Court of Appeal. The 3rd District said a defendant must disclose raw data from mental health experts prior to a penalty phase proceeding. The defendant in Abdul complained that the trial court erred when it ordered the defense to produce raw data from the defense's mental health expert prior to the penalty phase. The Florida Supreme Court disagreed with the defendant. The court reaffirmed that Rule 3.220 applies to the penalty phase proceeding and noted that the mandated reciprocal discovery includes disclosure of reports or statements of experts. The defense battled this issue very much so. They did not want to turn over the raw data. Then they tried to get a compromise as to what it could be used for. The court's order, the court granted the order, and then I believe the defense asked for a rehearing, and they wanted to try and put limits on the disclosure. And the court ended up having it turned over directly to the state. The court order states from January 24th, 2022, that the court finds that the defense expert shall provide all materials used and made in connection with this case, including raw data, directly to the Office of the State Attorney. The Office of the State Attorney then may only share such material with any experts or consultants in the field who are consulted in this case. The sharing of such materials shall be done securely, and any experts or consultants who gain access to this material from the state shall not disclose the material to any other individual. Such raw data materials shall not be copied by any party or individual, and such materials shall not be made publicly available or become a part of the record in this case. The court notes that providing the Office of the State Attorney directly with the materials in this matter is for the purpose of streamlining the process and to ensure efficient and seamless consultation with its experts. Furthermore, although this court does not believe this would be done, the attorneys are not to use the raw data to attempt to form their own interpretations or analyses of the materials. All interpretation and analysis of the data shall only be made in consultation with its experts. I'll state for the record that the state did consult with its experts before the deposition. Your Honor, the defense in their entire 11-page motion, this motion in limine, cited one case, and that case was a 1949 decision from the Florida Supreme Court called Pepper. Let me see if I got the pronunciation. I think it's P-E-P-E-R versus Adele, E-D-E-L-L. And I'm sorry, it's Perper, P-E-R-P-E-R. 44 Southern 2nd, 78, Florida, 1949. This case has nothing special to do with this particular case. There's nothing particularly on point about it. It's essentially a 403 analysis that if the evidence tends to confuse or obscure rather than illuminate the true issue before the jury, then the evidence should be excluded. The state would argue and will further argue, and it'll be clear as I get further in my argument, that the state's cross-examination actually doesn't, it actually illuminates the true issues before the jury instead of obscuring or confusing. This opinion, so the defense has no case law to support their argument that they are making today.
That's right. A weird argument.
The defense adds in an exhibit B, which is the APA, I guess that's the American Psychological Association guidelines for psychological assessment and evaluation. And they quote extensively to the APA guidelines. What they don't quote is what are the APA guidelines? What exactly, who does that cover? They have somehow placed me as the prosecutor as someone who did not administer the tests correctly, like I'm a psychologist. I'm not, I'm a lawyer. I'm a lawyer doing a deposition.
That's right.
Now they have placed the American Psychological Association guidelines for psychological agreement on me as the prosecutor in this case, when it doesn't apply to me. I'm a lawyer, not a psychologist.
Oh.
And in fact, on page 4 of their own exhibit, it makes clear that this is for psychologists. And then it makes a statement distinguishing between guidelines and standards. And it says, the term guidelines refers to statements that suggest or recommend specific professional behavior, endeavor, or conduct for psychologists.
Yep.
Guidelines differ from standards. Standards are
That's from our
mandatory
ethics code.
and thus may be accompanied by an enforcement mechanism.
It's very strange.
By contrast, guidelines are aspirational intent. They are not mandatory, definitive, or exhaustive.
None
They
of that
aim to
matters to the
facilitate
test. That
continued
is
systematic
governing
development
over the
profession-
behavior of
of the
psychologists.
professional and to promote a high level of professional practice by psychologists. It goes on to state that as a result, guidelines are not intended to take precedence over the professional judgment of psychologists that are based on the scientific.
Okay, let me explain why I'm laughing. What he is reading, okay, he is reading from the motion by the defense. Okay. They're saying that he in this enactment that you watched yesterday with the state psychologist, Dr. Michael Brandon, the defense is saying that they can't use that deposition, like the way they read it back and forth, that they could have shown the deposition like on a video, right? But instead they chose to act it out with Dr. Brandon playing the role of the defense psychologist, Heather Holmes. So as they talk about the deposition as in relation to the results of the Vineland specifically, because that accounting of adaptive behavior is going to make their argument foolish, because the jury's going to know the reality of the kid and how he behaved in his early life and whatnot. So they're trying everything they can to get that thrown out. They don't want the results of the Vineland in. And so in their argument saying, hey, you know, it's a copyrighted test. We can't have it in the courtroom available to the public because it's copyrighted. Now, mind you, that's not Pearson Publishing that's making the argument, it's the defense. And then secondly, for some bizarre reason, they have put into the motion the ethical guiding principles of psychologists. Like psychologists that would be in clinical practice, that might be working as diagnosticians, that might be forensic psychologists, they might be in private practice, they may just be doing counseling. We have a code of ethics and then guidelines for professional behavior. Those are our guideposts, the lodestar for our behavior. Now, some of it will parallel or intersect with legal requirements by, in my situation, the states of Texas. I'm licensed in multiple states. I'm not going to name all of them, but I have to follow the legal requirements of the states. But then I have from APA, if I'm a member of APA, then I have to adhere to the code of ethics and the guiding principles, which really don't have any legal weight, but they certainly might interfere with my ability to keep my license intact, or at the very least to maintain my membership in the APA. So it's so bizarre to hear that they included these in this motion to keep out the Vineland, because he's an attorney. He's not a psychologist, and he didn't administer the test. He just talked about the results of the test, which are freely available depending on who the parents or who the school want to release the information to. So it's very odd. It is very strange. What their motion is odd, to say the least. So I'm laughing because he's reading the guidelines for professional ethics by APA, which absolutely have the ethical guidelines have no legal teeth. You can violate them all day long and nobody's can come arrest you. I mean, we won't, because we're really concerned about a very high standard of care. That's the whole point of being in good standing with the APA, is, you know, that you're conducting yourself in a way that every licensed psychologist, well, not licensed even, but every member of the APA would be expected to behave, that you're following best practices standards, that you're showing good ethics, that you have strong integrity and personal responsibility. It's just weird that ended up in this motion. It's just strange. I don't know who was thinking of, I can't imagine who on the defense thought this was even applicable. It's strange. It's so strange. It's so strange.
And professional knowledge of the field and the ethic codes. And this is the most important line here. Further, federal and state laws also supersede guidelines. So these psychological APA guidelines is completely meaningless because state law controls that the raw data can be shared with both parties. Equally, Exhibit C is ethical guidelines APA ethical principles and code of conduct.
Welcome, Snow Lion.
And I'm not sure why they have sent this as well, because it applies to psychologists. It doesn't apply to lawyers who get a court order to obtain the documents. And in fact, on page 2 of 4 of their exhibit, under 9.04 release of test data B, in the absence of a client-patient release, psychologists provide test data only as required by law or court order. So Exhibit C, like Exhibit B, is completely and utterly meaningless to this hearing. That is the authority
I
that
agree.
the defense is trying to use. They're trying to use.
Hey, Robbie Lee, welcome.
the
I'm with
ethical
you, Robbie. Get him
guidelines
going,
and,
right?
The code of conduct of psychologists, completely meaningless. Now, the defense did not include, there are other guidelines, but more specific for forensic psychology.
Yep.
And I have a copy of that, and that's not the law.
And these are going to
here
be from,
either.
these are going to be
Those are
state
guidelines for forensic
law. These are coming
psychologists,
out
and
of
that's
state
what we're
licensing
involved with is
laws.
forensic psychology. And I do have a
So
copy
they do have teeth.
for the court and defense. I would like to offer it as a state's exhibit.
Welcome, everybody. This trial is for Nikolas Cruz. It's a motions hearing. The opening statements will be Monday, July the 18th. So we're just kind of getting ready, getting to know the attorneys that are there, how the judge operates.
No, and I'm not suggesting.
So
that
welcome.
this
I'm
is
glad you're
law
here.
that
I hope you'll stay and watch
governs,
with us.
This case either.
And I do have a
It's-
scratchy
it
voice, and I
only stands
apologize for that.
The proposition under paragraph 11, that's on page 16. Forensic psychologists know that when they go into that business, they will have to turn over data if there is a court order that tells them to do that. They do have ethical responsibilities of when to try and resist if possible. But once
But
there's a court
ultimately,
order,
the law is the
that's
highest
it.
standard.
They
You
have to
have to
turn
go
over
by
the
the
data.
law,
That's
even
their
if it goes directly
responsibility.
against your professional
And,
ethics.
in the middle of
Or you
it's
can go to
actually
jail.
Guideline
It's your choice.
11.01, accuracy, fairness, and avoidance of deception. When responding to discovery requests, providing sworn testimony, forensic practitioners strive to have readily available for inspection all data which they considered, regardless of whether the data supports their opinion, subject to and consistent with court order, relevant rules of evidence, test security issues, and professional standards. So, Your Honor, the defense psychologist they can make their objection, which under their ethical requirements, they may be required to. And they did that through defense counsel. But that's as far as it goes. Once the court orders its release, it does get released. And that's what happened in this case. It was released.
The law is the highest standard. You have to adhere to your guidelines, but ultimately, the law.
Your Honor, the defense.
Actually, I
has
said
now
that backwards.
filed,
Your ethics are your highest
state's
standard,
exhibit
but you can go to jail
F.
if you decide to go against the law.
um,
So you try to
which
resolve
is,
it and stay within your
purported
code
to be,
of ethics.
what questions that I asked at deposition and which they found a similar subject matter in the violent threat.
And to be specific, I didn't want to interfere with what he's about to say, but to be specific, in the case of forensic psychologists in Florida and Texas and a couple other states, the practice of forensic psychologists is heavily scrutinized by the state. So there are very specific legal guidelines for what they must do. And if you're a licensed psychologist, you have legal responsibilities in parameters that have to be met, right? For forensics, there's an additional layer if you are working and practicing in forensic psychology. What he has just read were not legal guidelines. They were from the APA. It's a professional organization. Now he's going to go in more into forensic legalities and this issue with the Vineland.
The Vineland 3 measures adaptive behavior. So there are areas where you would normally ask a witness in deposition who is familiar with that person during a certain time period about their adaptive behaviors. It could be combing their hair or going to the bathroom, things related to the timing of when they may have accomplished those tasks or brush their teeth or things like that. And some of those things are questions.
If they use
that I
two-word
ask, and I will go through
sentences, at what age
What's
did they
important
make eye contact and greet people appropriately?
to the state is some of the answers that were given. In the Vineland 3 by Finney Browd, purportedly to Dr. Brown. When I say purportedly, Dr. Brown contends these were answers that she was given. Finney Browd had no memory of even being asked the subject matter of some of these questions. The Vineland 3 and the results were given to some of our experts, including a Dr. Gilmet. And Dr. Gilmet's deposition was kind enough of the defense to include that as an exhibit in their motion in limine. And that is Exhibit H, deposition transcript by Dr. Gilmet. Now, on page 62 of Dr. Gilmet's deposition, he's a forensic psychologist. On page 62 of his deposition, he is addressing at this particular question the results from the Vineland 3 from Finney Browd. And on page 62, lines 11 through 16.
Okay, 62. Lines 11
Yeah.
through 13.
Yes.
I'm on the page.
Okay. So his response, the question was asked, or his answer was that Finney Browd's responses from the Vineland 3 would have indicated that Mr. Cruz, or did indicate, as it was scored by Dr. Brown, that Mr. Cruz had a receptive language ability of 1 year and 8 months. So this was supposedly when he was 11 years and 9 months old, that based on answers that Dr. Brown said that Ms. Browd gave on the Vineland 3, that he had a receptive language ability of 1 year, 8 months. And as an example, one of the questions that was asked on the test, as well as a question that I addressed in deposition, was at the age of near 12, 11 years, 9 months, how many words did he know? Did he know? And according to the Vineland, he did not know even 50 words. And that would be a reason why his receptive language ability would be 1 year, 8 months. If at nearly 12 years of age, he didn't know 50 words. That is completely absurd.
Judge, I'm going to object to the relevancy of these questions. The issue before the court is whether or not the state of Florida can ask Vineland-type questions during the perpetuation of Finney Browd's deposition. It's not to get up here and try and get into evidence what other experts are saying. So we would ask that Mr. Marcus tailor his position and his argument to the intent and the spirit of this motion before the court.
This is the reason why it's asked. We always have an opportunity to question a test. A psychologist doesn't get to give a test and doesn't get to be questioned as to why this result is appropriate. They can't cite one case that says we can't. That's why we're able to get the raw data so we can question it. We're not getting the raw data so we can ignore it. It's to look into, is this raw data accurate? They have a problem with this because there's tons of school records. Everyone knows what his progress was in school. He was not at 1 year and 8 months when he was nearly 12 years old.
Nancy, that's inaccurate. It's not real. He was in school. He was reading and writing. There's no way of
Indeed,
knowing
any
where they
question
came in with that
came out
number
of the
from.
deposition,
Whether he
was
was
that-
malingering or
or
the
a subject that
there's
came
no
out
way
of
of
the
knowing.
deposition not having to do with the Vineland had to do with when Mr. Cruz's father died. He was nearly 6 years of age. Miss Browd stated that when she saw the defendant right after the death, he asked her, is my father going to heaven or hell? And he was not yet 6 years of age. So clearly someone who could not even form 50 words at 12 years old, at less than 6, wasn't going to be able to understand concepts of heaven and hell
Exactly.
and articulate such a sentence. And
exactly.
Miss Browd articulated many more words than that he was aware of. So it's clear that the Vineland
Hey,
answer,
Pinch, welcome.
which was that he did not understand 50 words at 12 years of age, is an incorrect answer, in that Miss Browd was able to articulate many more words that he could speak, and then looking at other data, and then this is from the psychologist, looking at all the other data, it would have been notated in the school records that he was that far behind. So the Vineland on its face,
He basically
was
would have been
incorrect, at
identified
least
as
to that
nonverbal.
question, and several others that the state got into the deposition. Dr. Guillemette further testified at the deposition that, and I'm looking at now page 69, starting at page 68, line 24, defense asked, when I asked you about the deposition that I think is the second one, April 7th, 2000, it says 2002, it should be 2022. You said that the answers in the deposition were inconsistent with the answers on the Vineland. Did I understand that? Or were different, or that's what you took away from the deposition? Yes, that's the answers reflected a higher level of functioning. This is an expert witness for the state, having read the deposition that the defense complains about, can see from the deposition that his functioning is not as was described or reported by Dr. Brown's analysis of the Vineland. It was further his opinion on page 71 of the deposition that the Vineland results do not reflect his functioning, his functional adaptive behavior. The questions that were asked by the state did not reference the Vineland specifically. I was asking questions that are just typical of what adaptive behavior, what accomplishments, what the defendant's capabilities were. On page 34 of that deposition, I believe is April 7th. He was,
Ms. Brown's demo?
yes, is it April 7th?
She had two, so
The first one was in December.
there is April 7th, yes.
Thank you. The questions asked: at ages 4, 5, and 6, were you around the defendant when he was eating? Getting information about how he ate. That's an adaptive behavior. The specific age that Miss Brown was supposed to report on, according to the Vineland, was at 11 years and 9 months. I was asking at different ages, because if you could accomplish at a younger age, then then presumably he was retain that skill when he's older.
And that's a good line of questioning. Somebody
She
can make a
reported that he
mistake
would
just like
say, I
anybody.
don't want this, I'm not eating this. Again, this is ages at 4, 5, and 6. These are words that he's saying as well. She could understand him at those early ages, 4, 5, 6. She would explain to him that he needed to eat what his mom made, and the defendant would understand. She indicated that at the ages of 4, 5, and 6, he was able to watch cartoons like a normal kid. At the age of 7, he would watch the History Channel about animals at 7 years. These are all behaviors that Dr. Brown states in the Vineland that he did not have the abilities to watch a show like that even at 12. That he was a help in the kitchen as a young boy, that he was able to set the table, including plates, napkins, forks, and knives. At age of 6 and 7, he was using a microwave. He helped feed the dog. He was doing chores at 6. He understood what the word no meant, which was indicated by Dr. Brown that he didn't understand the word no. There was questions about gestures. What gestures could he do? And Ms. Brown didn't say at 12 he couldn't do it, as was indicated in her responses. She said that at 4 to 6 he understood what these gestures were such as like a finger, as I'm indicating, Your Honor. I'm using my pointer finger as a gesture like come to me. He understood a sleep gesture, putting hands on one side like a sleep gesture. He understood if you put your arms out, that was a welcoming gesture, and he would come in and allowed to be hugged by Ms. Brown. These were gestures that he understood that Dr. Brown said didn't happen, did not give him credit for these things. That he clearly knew 50 words at 6 years, let alone 12 years of age.
That's right.
There was also the concept of knowing things such as behind or in front of or between, like a toy being in front of a couch or behind a couch or between cushions. She said he knew all of those concepts. She also testified that there are some things that she doesn't recall because it's too long ago. And quite frankly, that is one of the criticisms of it's called a retrospective test, in that you're asking somebody to 10 years later, if they were a caretaker or had a lot of exposure to the person, to be able to say, what do they do when they sneeze? People may not remember how they handled a sneeze. In fact, our doctor says, I can't tell you what my 6-year-old did at 6, or my child who's not 6 years is way beyond that now. I can't tell you what he did at 6 years. Can't tell you if it was 6 or 8 or 10. I know that they did this, this, and this, but I can't tell you at what age. This test is asking, okay, at this age, at 12, did he do this? Did he do this? Did he do that? And several of those questions were asked, and she said, I remember events. I can't tell you what date they were. So this all goes
But
to
the test does
credibility
do
of the
that.
examination that was given by Dr. Brown. He indicated, or she indicated, and Ms. Sprout indicated that the defendant brushed his teeth when he was 6 to 7 years of age, which was indicated at 12 that he didn't. Whether or not he could zip up a jacket or button a shirt, that he could play a game like Tetris on the phone at 6 years of age. These are all relevant questions as to his adaptive behavior. Whether it was related to this particular test or not, these are appropriate questions to ask because adaptive behavior is an important component in determining whether or not he qualifies under the diagnosis that the defense is contending that he has.
Okay, so just let me kind of pop back in here for a second. Welcome, Aileen, or Eileen from Scotland. So what is the purpose of a motion hearing? Well, it can cover a number of things. In this particular hearing, the defense doesn't like testimony where the prosecution is saying, okay, I got a better way to describe it. Hold on. Okay. In the United States, students that are in special education, they undergo testing by an educational diagnostician approximately every 3 years. That number can vary for different reasons, but let's just say as a standard every 3 years for determination of services, school services. So this particular defendant, Nikolas Cruz, he was 19 years old. He had graduated from Marjorie Douglas Stoneman High School in Florida. He had been out of school for more than a year when he plotted and carried out the shooting. It's a school shooting of 34 people. 17 died, 14 were students, 3 were teachers, coaches. So 17 died, 17 were badly injured. So because this shooter had been in special education from elementary all the way up to when he graduated, the state has a dramatic treasure trove of objective testing. There's also projective testing. There's achievement testing. They have an unlimited amount of information about Nikolas Cruz with dates, age ranges, times. I mean, they know this is a very interesting case that we have a school shooter now that we literally know everything about his developmental trajectory, everything. This is a first time. It's amazing. The what could be learned about this whole problem of school shooting and acting out. There's a great deal of great information. It's a unique case. So in all of this information, the defense found the prosecution found a test. It's called the Vineland 3. The Vineland is also used in Europe. So Eileen, there would be people in Scotland, psychologists in Scotland, that would know what the Vineland is, just like the Wechsler or whatever. So the Vineland 3, it goes through and it says, from ages 4 to 5, was this kid able to set a table? Could they greet people appropriately? Could they advocate for help in the community? Can they hop on one foot? You know, a wide range of adaptive behaviors, and it's just a counting of what should be developmentally appropriate ages at any given age. And so even if they gave the Vineland when he was 12 and it showed something bizarre, like he had less than 50 words, his receptive language was less than 50 words when he was 11, nearly 12 years old, you could still go back 3 years before or 3 years after and pull that Vineland that was used to compare it, right? So the defense, of course, their job is to try to provide as many mitigating circumstances as possible because they're trying to avoid the death penalty. They're trying to get life in prison for this kid. He's already admitted that he's guilty, Aileen. He's already admitted to it. So this is about penalty. This is, are we going to kill this young man, or are we going to let him stay in prison for the rest of his life without possibility of parole? And so the defense has to offer up reasons why he shouldn't be killed. And they ran across this Vineland that said, you know, when he was nearly 12 years old, 11 years, 8 months, that he had a receptive language of 50. And I would turn around and say, okay, but what was his expressive language? Because how can you reasonably expect an expressive language of over 500 words to compare with a receptive language of 50? That's just silly. Doesn't make any sense. So that can happen. It could be error, the respondent's error, whether it's being filled out by a parent, whether it's being filled out by the psychologist in an interview fashion, whether it's being filled out by a psychologist in a testing environment. The psychologist could have accidentally, or the parent could have accidentally marked an incorrect number, which threw off the ultimate standardized result. But there's enough information because he was in the system, because he was part of the special education federal protection. His whole educational career has been documented, well documented, and so rightfully so, as the defense says, well, we're going to make this argument that he is severely intellectually handicapped, severe disability, right? And then that can be used as a mitigating factor to say, well, we don't put to death people with, what we used to call mental retardation. Now it's called intellectual disability, to be more in line with the federal laws for people living with disabilities. So now it's called an intellectual disability. Okay. So the prosecution responds by going, what do you mean he's 12 years old and he only has receptive language of 50 words? That can't even be remotely possible. So they subpoenaed the system, the state of Florida, for his educational records. They wanted to see what was there. And so they've gone through and they have found people, whether it was the special education teacher, or whether it was the educational diagnostician who did the testing, and they questioned them. Well, you knew Nikolas Cruz at this age. Tell me what he was like. Well, if he's 4 or 5 years old and he can set the table with a plate and a couple of utensils and a cup or a glass, if he knows to go wash his hands after he uses the bathroom, he obviously has a receptive language that far exceeds 50 words, even at age 5. So that one Vineland protocol that has him 11 years, 8 months, and having a receptive language of less than 50, it was a mistake. Someone messed up somewhere. And so they're trying to stop the prosecution from being able to interfere with that mitigating factor. The defense is trying to hold on to the ability to say, hey, This kid is 12 years old. He didn't even know 50 words. You can't put him to death if he's that severely intellectually disabled. It would be immoral. We don't do this in our country. And the prosecution's coming back saying, BS, it was just a simple mistake on a testing protocol. And here's all the evidence for why we believe it was not an accurate reflection of his abilities and adaptive behavior at that time. Okay, so there it is in a nutshell. I hope that makes sense, Eileen. I think it's Aileen. I think you pronounce it Aileen. Hey, BBT Boston, how are you? Run across any dog? Oh, I'm not going to say it, but you know what I'm thinking. So kind of like invaluable in terms of a researcher's perspective, in terms of how to use this to identify these kids in the future. It's a damn good start, Blonde PT. It is a damn good start. Absolutely. No, I think the suppression, specific to the Nikolas Cruz, Marjorie Stoneman Douglas shooting, and the amount of developmental and intellectual and academic development across his school career. Because he was also, here's another factor. He was diagnosed, and BBT Boston knows this. He was identified as emotionally and behavioral disability. So he's got a lot of bad behavior, emotionally unregulated, distress tolerance was very, very low. That was really primary over his intellectual type of disability. His IQ, I suspect his IQ was above 70. So somewhere probably between 70 and 80 would be my guess. And they're trying to say with the adaptive functioning from this one Vineland, they're trying to say that he should have been, not just emotional and behavioral disorder, but he should have been also identified as, intellectually disabled. But he wasn't. He researched weapons, firearms, for God's sake. He could discuss different calibers of bullets and what they could accomplish. He mapped out a strategic plan for getting into school, accomplishing what he wanted to do, and then escaping. He literally walked out of that building with the other students as if he were running away from the shooter. That is not a student with intellectual disability. I don't care who you are. It's not. BBT believes maybe around 88, which is that an 88 is inside normal range, right? That's right there. So I don't know. I'm thinking maybe he's a little bit less. It could be completely, totally wrong. But when they did genetic testing, he's got the fetal alcohol syndrome. That right there would suggest there's probably some intellectual problem, cognitive type disruption. But they're trying. The defense is trying to use an intellectual delay, an intellectual disability as a mitigating factor for why he should be spared the death penalty. And the prosecutors are they're calling bullshit. They're saying, no, it was a mistake on one testing protocol, that this kid was in special ed his whole school career. We have plenty of protocols with plenty of testing results to show that, yeah, he did have a good receptive language. I guess I should say adequate receptive language. BBT thinks he's not that low functioning. Yeah, he's not dumb. He damn sure knew right from wrong. Robbie Lee agreed 100%. He knew right from wrong. They can't even approach that argument. This is just the range that they are the most dangerous. I think Snow Lion. So Columbine really captured my attention. I mean, it captured everybody's attention. But I was very interested in Columbine. Sandy Hook came around, And you know, with Columbine, professionals in the psychiatry, they were of the opinion that this was the result of bullying, that bullying created such a great degree of animosity and loss of control, a sense that your power had been taken from you by the bullies, that it was a rubber band type reaction. And that by planning out what they did at Columbine, by planning it out, practicing, they video recorded one another, they had manifesto, that all of that was actually a process of them regaining their sense of control, and that the actual act itself was somehow secondary, that they were really driven by the reward that they were getting, the intrinsic reinforcement from reestablishing power and control, that the bullying that they had received, they were outcast from the general school body. And so by exercising this control, they felt more powerful. Some might even say it even morphed into like a type of narcissistic supply, that there was some toxic type of fill that they got. Not in the beginning, not when they started, that it started out as fantasy. I'm talking about with Columbine. That started out as a fantasy, but as they intrinsically began to enjoy the sense of control reclaimed, that sort of grew into a mask where they are these mafiosa, powerful hitmen. They had a secret. And as they walked through the hallways of the school, they felt almost godlike in knowing that these people would die, and those people did not know they were going to die in the planning, in the weeks and months leading up to it, right? So that was sort of like the overriding that was like a developing theory. That was the rule out essentially for researchers. Is this school shooting problem, is this the result of bullying and the inevitable loss of control? Is that why they do it? Right? Sounds good. It's trauma. Being bullied is trauma, right? But then Stone. But then the other shootings began to emerge where there had not been bullying, right? There was not bullying. And yet you still had these kids that were acting out this crazy scenario. And unfortunately, a large number, a percentage of these shooters are on the spectrum. And so people that specialize in the spectrum, specialize in research regarding people that are on the spectrum, they know that people that are on the spectrum will very often do what is called scripting. They'll mirror and mimic behaviors. They struggle to know the fluidity related to the social environment is not, it's not there. And so often when they don't know how to react, they're at a loss of what they're supposed to be doing. They'll look to other people in the environment and they'll act out what they're watching, or they'll script. They'll hear a cartoon or something and they felt particularly relaxed or happy during that cartoon. And then it's almost like a recorder in their head. And so then when they begin to feel nervous, they'll actually mimic word for word what was said during that cartoon. Some of them have a comfortable sentence or two that they'll repeat, but hey, I've seen kids that could go through an entire movie and they could say every word. So you know, so with the case of Nikolas Cruz, he was the bully. He was the kid in school that everybody was afraid of. A lot of people say, "Oh, well, you know, it was because of, you know, he was adopted, so he must have been treated bad." Well, in reality, his biological mother gave him up for adoption when he was born. He was an infant when he was adopted by his adopted parents. That they had plenty of money. It was not just middle class upbringing, it was upper middle class. Lived in a very beautiful, expensive home, protected neighborhood, best schools. They had a lot of opportunity. His brother, his biological brother, graduated college in the science field, is doing fine. But Nikolas Cruz never fit in. He seemed to have entered the school system angry and socially awkward. So this is a it's a horrific case. No question. It's heartbreaking, devastating. Those 17 lives that were lost were all exceptional people. It was a huge loss. So it's a devastating case, but it's also a highly valuable case because he was in special ed throughout the school career. And we have all of this really good data that can be used in pursuing these questions related to what the hell's going on with these, you know, teenage, basically mass murderers. All right. Hope I answered questions.
And this, so those were the issues that were asked of Fene Browd. So, Your Honor, it is entirely appropriate. The state receives the data, went over it with its experts, and formed questions in a deposition that were important to determine if this test itself, the Vineland, is accurate. Because you're asking people to remember something that happened. In this case, it was about 10 years earlier as to what he did, his adaptive functioning in each of those areas. What she could remember was inconsistent with what Dr. Brown reported. And this is a valid cross-examination, and it produced data for experts to look at. As Dr. Gilmet looked at this data that was created in my deposition of Ms. Browd, and can say, this Vineland test is not something that can be relied upon. If you not only look at the deposition, but you look at all the data that they have from his school records, you could see that he was not at 1 year and 8 months at 12 years of age. That would have been documented in records, which indicates that either Ms. Browd was a very poor reporter or Dr. Brown did an incompetent examination. Either way, it indicates that the Vineland test should not be a reliable piece of data for any of the experts to use because of all these problems. For all these reasons, these are valid matters that can be raised in cross-examination. How are we to confront this test unless we ask about data that doesn't make any sense to any of the experts? We're not in a position, or no party would be in a position, to merely accept what the psychologist is saying. We did not administer the test. I was a prosecutor asking questions in a deposition. Whether or not an expert can rely on that information, this all goes, it goes to weight. It doesn't go to admissibility. The jury should hear what the competing stories are, and they will have to make a decision as to whether or not the Vineland is a reliable test or not. The state's position is that it is not reliable, especially how it was done in this case, especially with Fene Brown's subsequent answers, where she doesn't support any of the answers that Dr. Brown says. I won't say any, several answers she does not support, some she does support. But those are important distinctions as to what level he would be at. So for all those reasons, I ask you to deny this motion.
May I respond, Your Honor? Yes. So at the beginning of Mr. Marcus's presentation, he said that during the deposition, there was an off-the-record conversation about questions he was going to ask relating to the Vineland. That was actually in reference to the personal behavioral checklist and the brief symptom inventory. I made those objections because I thought that the brief symptom inventory, also known as the BSI, was copyrighted. We stopped. I contacted Dr. Brown because I wanted to make sure that we weren't violating or participating in the violation of a court order or violating any copyright laws. And she said that the brief symptom inventory, also known as the BSI, is widely used and can be used by non-professionals as well as professionals. So there was no copyright issues. So I just wanted to clarify that. It had nothing to do with the Vineland. The defense is still not in possession.
I think my conversation was with Ms. Curtis, not with you, as I recall.
I have a different recollection.
Yeah, you had that conversation with me.
You were on the depot, right?
No, but we're talking about a different I'm sorry.
Okay.
We're talking about a different deposition.
Well, then you can make that in your argument.
I'm not making any argument, trying to help you.
Thank you, sir. I never would have agreed to allow any, or no member of the.
They are all sick of each other. I'm telling y'all, this is going to be an explosive trial.
The deposition piece of trial was taken and was sent to a defense expert that we were advised that portions or questions from the Vineland were administered to Mrs. Brown. We still do not have the raw data because we do not believe that we should have it. And just in terms of.
Oh, so they closed their eyes when they got to the Vineland, right? Come on, Melissa. Damn, Melissa. What the hell, girl? Tighten up. Get it together.
And then on May 21st, May 21st, 2022, after our experts contacted us and said we cannot comply with this court order without protected language. And their concerns were that releasing test data to individuals who are not trained in the administration and interpretation of the data is a direct violation of the American Psychological Association's ethical guidelines for psychologists and neuropsychologists. Their second objection was releasing raw data and test instruments to unqualified professionals, Mr. Marcus, or myself for that matter, increases the risk and likely possibility that the data and the findings will be inaccurately interpreted. The analysis will be limited to admitting standardized and findings.
BBT, that judge is a hottie. She is what every woman aspires to be. She is tough. She's powerful. She is beautiful, and she don't take nobody's you know what. It has, Robbie. It's been crazy for sure.
By consenting to the release of copyrighted and confidential materials to those not professionally qualified to obtain them. We had a full hearing. I'll rely on those pleadings because we added ethical considerations for both forensic psychologists as well as neuropsychologists. And the court did sign an order. And that order was January 24th. And Mr. Marcus read part of the order into the record. But what the court also said in that order was, furthermore, although this court does not believe that this would be done, the attorneys are not to use the raw data to attempt to form their own interpretations or analysis of the material. All interpretations and analysis of the data shall be made only in consultation with the experts. So this is the objection that the defense has. The Vineland 3 is a standardized, normed instrument. And one of the reasons why when you are assessing individuals' adaptive function, that this instrument is used is so that it is always administered the exact same way. That's what makes it reliable. You're not supposed to use open-ended questions, as the author of the manual says. You're supposed to use either a comprehensive interview form if you're a parent caregiver, or a comprehensive interview form if you're a teacher. The questions are graduated. So, and I use this one in the deposition. The question is, does your child brush his teeth? Yes, my child brushes his teeth.
Hi,
Well,
Chris.
how many times do you have to ask your child to brush his teeth before he brushes his teeth? Oh, 10 times. So after you ask him 10 times, does he brush his teeth? Well, I actually have to walk my child into the bathroom. And then does he brush his teeth? No, I have to get the toothbrush out and I have to put the toothpaste on the toothbrush. So if the question is, does your child brush his teeth? And you say yes, without any probing, which is exactly what the Vineland is supposed to do, finding out all those other steps, you have an accurate measurement of adaptive function.
I will, Zelda. Thank
So
you.
that's the reason why unqualified and untrained individuals are not supposed to cherry pick questions from a standardized measure and ask individual questions about adaptive function. In fact,
Mistakes are made, Melissa.
1 second.
Okay? Mistakes are made. Educational diagnosticians are human.
Dr. Belmetti's deposition, who, for the record, has never administered the Vineland 3 and only bought the manual for the purposes of this case. I asked him on page 79, line 8. I only have a couple more questions. Just let me look at my notes. Is it appropriate to rely on Vineland questions that are administered by a non-professional? Mr. Marcus objects, asked and answered. Witness says, I don't think he answered it. That's what the witness said. And then I say, you can go ahead. Answer, you mean to take a Vineland question in the Vineland format? Right. Answer, I don't, a lot of questions, does it make I question? Well, tell me what makes the Vineland assessment reliable. Answer, well, the assessment means that it is administered in the way that it has been standardized, that it was standardized. Question, okay, so if a non-professional asks Vineland questions, is it appropriate to rely on those responses? Response, so long as they're not saying that this contributes to a Vineland score in any way. It's a question that's out there versus asking the question from the Vineland and then using it in a way to indicate that this Vineland scores or that this contributes to a score in a Vineland. And then I ask, well, so there's a lot of questions that you can ask a person about a person's functioning that would be equivocal to the questions that are on the Vineland. That was his answer, I'm sorry, question. But the Vineland questions are done systematically and methodically, correct? Their expert said, yes. Question, and the answer should be more than, and the question should do more than govern a yes or no response, correct? In order to do a proper assessment of adaptive functioning. So, Mr. Marcus, and it appears to me that he's conceding that he used questions from the Vineland. I only know that because my expert reviewed the Vineland and then the deposition. Took questions out of an instrument, and there's 3 domains on the Vineland 3. He didn't ask all the questions in the Vineland. So even if he was a qualified professional to administer the Vineland, he didn't administer it the way that it should be administered. So that makes any information that he gathers unreliable because he's taking information from a test and he's using it inappropriately. Not in a standardized measure, which guarantees the reliability. If Mr. Marcus believes that the evaluation of Finney, or the Vineland that was administered to Finney Brown is not a reliable piece of data, he can have his experts provide testimony in their case or in rebuttal. Mr. Marcus is not a qualified individual to make those assessments. Our objection initially was that the state, and Mr. Marcus is correct. The court did say that the documentation could go to the state's expert. So I'll correct that statement and I'm in agreement with that.
The state.
To the state, and then they could administer it to their states, to the state's expert. But our concern, which is consistent with the concerns from the American Psychological Association, the ethical principles of psychologists and code of conduct, and the other document that Mr. Marcus relied on, was that attorneys should not attempt to form their own interpretation or analysis of the material. This is exactly what Mr. Marcus did. He took questions, used them in a yes or no, eliciting a yes or no response, and that's what Mrs. Brown responded to. It was not asked in the manner in which it should have been administered correctly by the Vineland. I have one. And releasing this information consistent with the court order doesn't make it a free-for-all for everybody who has possession of it to use it. There still are limitations, which the court clearly recognized. That's why you fashioned the order that you did, so it would be consistent with the publisher's concerns. Just a moment, please. Using a map. And when Mr. Marcus asked questions directly from the Vineland, he not only violated the copyright laws, which is not an issue that we need to take consideration of, that's up to Pearson, but what he did was he improperly administered questions from the Vineland. The responses to those questions are not reliable because they're not standardized. Consulting with their experts about the raw data is 100% permissible. We've done it, although we don't believe we have the right to possess the data. The state has actually taken a step further and done something that is 100% impermissible, not only in contrary to the publisher's recommendations or their guidelines as to what they're asking the court to do when they believe that they have to return the raw data over, which is to add the protective order, which is what the court did. So Mr. Marcus has taken this data, he has formed an interpretation in his brain, and then in order to support what he believes that information means, he asks the deponent a question. And it's not the way that this test was supposed to be administered. As far as the affidavit, Judge, Mrs. Curtis can make arguments about whether or not you were in a position to be able to strike that. But our request is that you prohibit Mr. Marcus from asking Vineland-like questions. And Judge, we're going to bring a hard copy of all the exhibits for you so that you can see, and their own expert says that an unqualified individual should not be administering the Vineland, and that the Vineland questions should be done in a systematic and methodical way. And that would include all three domains. That's not what Mr. Marcus did. This is why the defense back in January of 2022 objected so strenuously about this material being turned over to the state. And they did exactly what we were concerned with. Very simply, Judge, this is a 403 argument. He doesn't know the material. He's not authorized to administer the material. He's not authorized to interpret the material. And any probative value of the answers to his questions is outweighed by the potential to mislead or confuse the jury. And I defer now to Ms. Curtis about the case law on the affidavit. And I believe she also has some arguments that we already made about Abdul when we first argued this back in January.
Miss Curtis is the attorney with the glasses.
For my objective, we already got two people arguing this already.
Melissa hates
But if we want to respond,
the prosecutor.
first of all,
Like, she can't even look at him without hate coming from her eyes.
point out the transcript of the deposition of Ms. Benet Browd that I was talking to Ms. Curtis. Ms. Curtis made an objection. Ms. Curtis objected. You're asking her questions now. And I said to Ms. Curtis, I'll talk to you on the phone if you like. You want me to do that? We'll go off a moment. And Ms. Curtis says, sure. And then we came back on. There was no other objections from the defense. So
Robbie, he has 5 attorneys. And then there's an attorney in Virginia with 2 witnesses that we don't know exactly who those people are yet.
Showing as on the appearances. So she wasn't even there for the deposition. She does not know what she speaks about what happened at the deposition. Next, the state, meaning me, did not administer a test. I asked questions that were relevant to his adaptive behavior. Those are questions that are in the Exhibit F. Questions like, did he know how to use a microwave? Did he know how to use a toaster? Those are not copyrighted questions. There is no particular, they had no, first of all, they don't represent Pearson. This is a penalty phase hearing where the raw data is appropriately with the state. They could have had it. They chose not to. And we turned it over to our experts. These are appropriate questions to understand what his adaptive behavior is, what his adaptive behavior was. Did he ever watch a documentary on animals or something like that? And they said they're liking it to a question that is on the Vineland, but it's not asking the exact question. It's the subject matter. It's all of his adaptive
That's
behaviors,
right.
that he has.
Come on, Melissa. Tighten up, girl.
Understanding appropriate behavior. That's why probably Vineland put it a similar question or a similar idea. These are not particularly unique ideas for adaptive behavior.
No, they're descriptive
What
ideas of
we were
adaptive
able to
behavior.
uncover from the deposition is that Ms. Brown said, I was never even asked a lot of these questions. I was never asked this question by Dr. Brown, which really goes more to not impeaching Ms. Brown, but more impeaching Dr. Brown for her examination and claiming that these were questions that were asked and answered or in her interview.
Very astute point.
How would we
Very good
know
prosecution.
if she did an appropriate examination? Who is there to tell us? It's Dr. Brown and Ms. Brown. We have to ask one or the other or both what happened. Dr. Brown contends this is what was asked. Of course, we ask the other person, is there what happened? What were the questions that were asked of you? And she answered those. Those are appropriate matters for cross-examination. The state is entitled to do a cross-examination of the witness. We get to test the witness's knowledge of what they know, and gaining information from Ms. Brown is also cross-examination of Dr. Brown as well.
No, Lefty, this was yesterday. The court is in recess today. The trial starts on Monday, July the 18th.
And they're pleading that this was related to Vineland. They're the ones
Welcome,
who,
Lefty.
if anybody violated the copyright, all there is a deposition where I'm asking about toasters and microwaves. There's no indication in my deposition that has anything to do with Vineland. I even went off the record when I talked to Ms. Curtis. It's whoever filed this motion on behalf of the defense told the world that it's Vineland. They're the ones who violated supposedly this agreement or the copyright agreement, but that has nothing to do with us. We're lawyers on a case. We appropriately had these materials, and only the psychologists, the experts also had these materials. It's their interpretation of the answers that's important. It's not my administering what I'm thinking in my mind. I'm not testifying in this case. I'm giving information to experts, and their experts are reading it too, and it gives them information. For example, you take a deposition of the defendant's brother. Any information that comes out of that deposition is considered data to a psychologist. It is data about how he grew up, how the defendant grew up, information about what happened in that home. That's whatever the question is, there's answers. The experts look at that information and then make determinations. Does it indicate this or that? Is it consistent with our experts' diagnosis, for example, of antisocial personality disorder? or not? Or is it consistent with what the defense theory is? Anything that comes out in a deposition, it's not for me to testify, it's for our doctors to look at that information and their doctors to look at that information and see if it's data that's important to their diagnosis. And that's all this is. It's not, I did not administer a test. I asked questions that were relevant to the test that was given them. Cite all the psychological guidelines and ethics that has nothing at all to do with this. It is all trumped by this court's order. And that is what controls. It is relevant information. Anything that comes from it, we can ask about. It's valid cross-examination. Thank you.
Judge, I just have a couple things and then I'll finish up. I just want to make a distinction between experts reviewing a deposition of Zachary Cruz or any lay witness and collecting data from that deposition. This is psychological testing that these experts are relying on in order to form their opinion. And these were questions that were taken from a psychological instrument that was standardized and normed, which equates the reliability of that instrument. The doctors cannot rely on Mr. Marcus's Vineland questions to make their evaluation. And our next motion will be how to limit their testimony, but Dr. Gilmetti does in fact do that in his deposition. So this is not normal data. This is data based on psychological testing, which is why the examiner or the forensic psychologist, the forensic neuropsychologist, and the publishers are so careful with who has access to this data and how it is accessed by individuals. And I'm going to request that the court hear arguments about the case law from Ms. Curtis because we were just handed this. And as I was preparing my argument to Mr. Marcus's argument, I wasn't able to read the case law. So I would ask that
It's
the
fine
court.
for today, but in the future, folks, each motion is gonna be handled by one lawyer. I know that there are 4 or 5 on each side, but,
Your Honor, this is their motion. We have to be prepared to argue motions. This is their motion, which they submitted one case on sort of a 403 issue from 1949, and they're complaining that they were handed case law. This was only filed at 5:30 last night.
Judge, the defense isn't complaining. We're just asking for an opportunity to review the case law that was provided. And if we have any distinctions that we need to make, that we're able to do that for the court. I also have a hard copy of all of the exhibits if the court wants it.
I accessed, they are in policy, and I was able to follow along on the computer as you all were making your argument, so it's not necessary. Okay, Ms. Curtis, you want to say something else?
Just with respect to the cases, and I haven't had a lot of time to look them over. However, these are both dealing with using affidavits as evidence in an evidentiary hearing to satisfy the party's burden of proof. This is not an evidentiary hearing. That affidavit was provided to give the court some guidance in an area in which the court may not be familiar regarding what we're talking about and why it's a problem. Similar to the affidavit we attached when we initially argued that the state shouldn't receive the raw data. There are hearings, it's not unheard of, that affidavits can be used in motions for summary judgment, for example. Affidavits or declarations used to support or oppose a motion can be made or must be made on personal knowledge, set out facts that would be admissible in evidence, and show that the affiant or declarant is competent to testify. So were we to call this doctor?
I think we're getting a bit off track here. I'm not concerned about the affidavit. So, however, I do find that the questions at issue that were asked by the state at deposition were fact-based questions that the state is entitled to ask for a number of reasons, whether it be to uncover relevant information or more specifically to undermine the validity of a specific test. This is the very nature of our adversarial system of justice, and the defense arguments, I understand them, but I think they go to weight, not to admissibility. So as far as the motion in limine to prohibit the state from asking these questions at the perpetuation of testimony on Thursday, that motion is denied. As far as making the record confidential,
Just exhibit F, Judge.
the record doesn't say, you all are the ones that added what the Vineland actual question was. The record is actually what Mr. Marcus asked.
Yep,
Correct.
That's
But some
right.
of the questions are the same or very similar of the Vineland questions, so we need those.
that's because it's a measure of adaptive functioning. How are you going to ask about what a kid can do without stating what a kid can do? Come on, Melissa. Damn it, girl.
To cross-examine witnesses.
You know what, y'all? This trial may do Melissa in.
I don't
She may not.
understand.
She may not
I
make
don't know
this
how
through
it's
without
clear. We just wanna make sure that the
pharmaceuticals. You know what I
actual
mean?
Vineland questions that are in that exhibit are deemed confidential so that they won't violate any copyright laws.
Melissa, you are not the protector of Pearson Publishing's copyright laws. They have their own attorneys for that kind of thing. It's a common instrument used for forensic psychologists and clinical psychologists alike.
Of the testimony that
And for you guys that don't know, I'm an alleged psychologist. For some people, that would be
from
confirmed.
asking any questions that relate
Yes,
to
Lefty.
any arguments made by the defense here today. If they're going to argue that the questions are similar, let's.
We need
this
Camille
court to rule
Snickers.
that those questions are permissible.
I am being clear, as clear as I
I
can be, that
understand
I
the
think the
court's wrong.
questions at issue that were fact-based questions and that the state is entitled to ask them.
Thank you, Your Honor.
Perpetuation of testimony and or deposition. All right, we're gonna take a 10-minute recess. It is 3:00. We'll take a recess until, we still have other motions, correct?
I'm sorry, Judge, for the motion to determine confidentiality of Exhibit F, you're granting that then?
Yes.
I don't believe the state has.
Granted by agreement, if you want, we can write up a short order, but
Okay.
I need to take a 10-minute recess.
Welcome, Hannah. How are you doing? Okay, so I think what I'll do, is it normal for courts to sit on weekend? No, Lefty. This was yesterday. Today the court is in recess as proclaimed by one Judge Scherer with both hands up. She said, attorneys, both, stop talking. This court is in recess. She had had enough of both sides. So this is from yesterday. I did also, so I put up a video yesterday that was from the day before that, where you had the state's forensic psychologist, and they were going through the questioning of Brown regarding the Vineland 3. So we listened to that. You could go back to that video. And then today is the culmination and ruling on that particular argument, why it should be allowed in. So, and today they're at rest, and the trial opening statements are Monday. So basically, Lefty and Chris, and those of you that are new here, maybe that haven't been in this channel before, I'm a psychologist, and from the time of this shooting 4 years ago, it happened on Valentine's Day in 2018 in Florida, Marjorie Stoneman Douglas school shooting. I was highly interested in this, this case specifically because this is a guy. He had been graduated more than a year, about a year and a half at the time of the shooting. He did return to his school that he graduated from. He was 19 at the time. And he had spent his whole school career from elementary to graduation in special education. Now, there were two issues at hand that made this particularly of interest to me. One is that in this country, in the United States, for people that have intellectual disability, the courts traditionally have avoided death penalty. And in many cases, they have avoided life without possibility of parole. That the intellectual disability has been used as a very effective mitigating factor, right? So that's number one. Now, because of confidentiality, but for education, we don't really exactly know at this point. We don't really know if he has a measured intellectual disability. Is he DID, or was he in special education for a learning disability with emotional and behavioral disorder? We do know it's verified that he has been, he was determined to be ED. So he was in special education for emotional and developmental, emotional and behavioral disorder. But and obviously there was some sort of intellectual academic delay, but we don't know if it was actually DID or if he has a specific learning disability. So we're not really sure. And I would imagine there was probably speech services and that type of thing. So because he's a school shooter, he was in special education from elementary to graduation. Number one, my interest is that this country has traditionally been quite open to intellectual ability being a mitigating factor, number one. And then the other reason that I was very, very interested is because school shooting has been a topic that I've been really focused on. So because there's some connection to autism, the rate of school shooters that are on the spectrum is notable. So I knew that because he had been in special ed throughout his school career, that there would be regular and ongoing testing throughout the years. There would be that initial determination. There's probably, because he is adopted, I would be willing to bet they even have preschool records on this child. So in terms of being a researcher and a developmental psychologist, being able to have access to all of that historical data on his intellectual ability, developmental delays, emotional intelligence, being able to map that out in regards to how that might correlate with the whole school shooting phenomenon is be absolutely invaluable. So there is an incredible amount that can be learned from this case. Incredible amount, truly. So this will definitely be one of those cases to file FOIA and get as much of the information as possible. And researchers in the area might even be able to get access to his education file if they can show proper school building level oversight and things like that. So, okay, let me again, I apologize for my scratchy throat. I know it sounds gross. I'm not really one to just kind of lay around when I get sick, though. It's boring. So keep my mind off of it, right? Okay, here we go.
Motion. Who's going to be my
Thank y'all for being here. I appreciate it. Just so you know,
point person?
opening statements are Monday, July 18th. 2 days.
Whenever you're ready, you can let me know what I am considering next.
This is just D300. It's the defense's proposed modifications to jury instruction 7.10, preliminary instructions and penalty proceedings, capital case.
Right, give me just a second to pull up that meeting, please. Okay, proposed modifications to jury instructions, D300.
Yes, ma'am. Judge, so what I did was I took the standard instruction. I don't know if yours is in color.
It's not, but I can see where you have made something, a different color, because it's printed in gray instead of black. It looks like it.
Okay, so there are certain.
Hey,
things-
Mark Gillespie, how are you today? Welcome. Good to have you here.
So, I mean, I don't know if you can distinguish, but so what I did was I did a strike through and red of language.
Hi, Glamis. I think I overlooked you when you came in.
Language that we asked to be added. There are only 2 green parts, and anything that's in red is struck through anyway, so you
Then,
might.
then I'm gonna have a problem, because anything that's not black just looks gray. But you said you put a strike through,
A
things
strike
that you
through,
want removed, and then,
yeah. So, I mean, I can just tell you, it's only a couple of things.
all right.
And then I did a footnote and citations and arguments. So I don't intend to make any additional argument. I put the arguments in the footnotes as to why we were requesting that. But in the second paragraph, starting with the attorneys will now have an opportunity. If you go about 2/3 of the way down, where it says are proven by the greater weight of the evidence, that has a red strike through. And then in green, which is what we would want said instead, have been established, and then footnote 1 explains
Okay,
why.
hold on just 1 second, please.
Okay, I'm sorry.
That's all right.
And the judge is already over the defense. She's sick of them. They have really been obstructionist, and I recognize that's part of their role. I do. But it has been,
Are you in agreement with any of this?
it's been very painful for the families because of the games that have been played.
Filed a response yesterday, a detailed response citing case law in opposition.
Okay, let me grab that too. My assistant is out. She's also awaiting a COVID test, so I don't have any.
Just FYI, I am not Judge Scherer's sister. Just wanted to put that out on the table in case y'all got confused. I'm just kidding.
I can print it. It's only like 3 pages.
Oh, mine.
Okay. No? I have a clean copy of the state's response if it will assist the court.
I have that. I was able, is yours in color also?
No,
Okay.
it's black and white.
So then I can print that myself.
All right.
Um,
Okay, so while this is sort of just sitting and watching them, I'll bring you a little example of the defense and some of the issues. Just as soon as I believe it was June 7th, I believe, the first week in June, second week in June, the public defenders for Nikolas Cruz tried to withdraw from the death penalty case after the judge ordered them to move forward with jury selection. Let me say this again. This thing happened February the 14th, 2018. We are now firmly in the middle of 2022 with countless continuances due to the games of the defense. And they finally get to the jury selection phase, which has just been put off 5, 6, 7 times. And they finally get to the jury selection phase in I believe it started the end of June 29th, maybe. And at, as early as June the 7th, where they were getting ready to get started on jury selection, right? They come forward and they say, "Oh gosh, Judge, so sorry. We have 5 attorneys. Like our team, the defense team consists of 5 people, right? 5 attorneys. One of them has COVID, and therefore we can't move forward with jury selection." And Judge Shearer, on top of being the hottest, most beautiful judge around, she's, well, she's also fairly tough. And she said, "Absolutely not. No, this is dumb. Of course, we're moving forward. We're done with this. It's time. These families need relief. You've got 4 other attorneys. We're going forward. Sorry, but not sorry. That's just how it is." So then when she said no, that she was not going to, hold off on jury selection, then the Melissa, I call her Melissa, right? First name basis, way they do when you're talking about trial testimony. So Melissa, her last name is McNeil. She's the lead attorney for Nikolas Cruz. So Melissa, she files another motion and she says, "Well, fine then. If you're not going to give me what I want, which is not to have a jury, then what we're going to do is we just want to be taken completely off of this case. We just want to be dismissed from this case, and you're just going to have to seat a whole new defense team for Mr. Cruz." And of course, the judge said, "I'm sorry, but I'm going to dismiss your request." And so then a motion was filed to delay the trial indefinitely because of the May 24th school shooting in Uvalde, Texas. Okay, so we've got all these delays for years at the hands of the defense. And then she tries to stop jury selection for the case of one person having COVID. And then she says, no, just kidding. The whole team wants to be off the case. Let us get off this case. We don't want to be here. And then when the judge says no, then she says, "Oh, by the way, did you hear about the 21 people dead in Uvalde, Texas? School shooter, just like my boy Nikolas over here. I think it's too prejudicial. I don't think it would be fair, not one bit, to move forward since the school shooting in Uvalde is all over the news. It's impossible for little boy blue, Nikolas Cruz, to get a fair trial because of Uvalde. It's absurd. It's absolutely absurd. If the defense team had not been engaging in all these stupid games, then all of this would have been put to bed a long time ago, long before Uvalde happened. It's just ridiculous. It's just absurd. And so, of course, after all of this drama, and of course, there was a lot of yelling. I mean, it was very dramatic. Judge Shearer said, "Look, just, you know what, we're moving forward. Just get it together, Melissa. Melissa, tighten up, girl. You're looking bad. You're making defense attorneys look bad." Okay. Now, this particular attorney that's speaking now for the prosecution, she's pretty badass. I like her a lot.
Establishes that, Your Honor. So I would direct this court's attention to the state's response. I'd also point out that what the defense has done with the red strike-throughs are not complete. They substitute the word.
Jury instructions are fairly boring unless you actually get the final instructions. Then you can go through them and, they're interesting. But all this arguing over words, I get distracted.
Paragraph that should come right after where it says mitigating circumstances, they take that out where it starts, "Should you find sufficient aggravating factors do exist to justify the imposition of the death penalty?" They take that out and they stick it right at the bottom. That's not accidental, Your Honor. These jury instructions came out post-Hearst in 2018. They were adopted and approved by the Florida Supreme Court in 2018. The case where it was done is cited in the state's response. And those instructions are before this court with the presumption of correctness and give.
Okay, now that is very interesting, isn't it? Anybody know why that's interesting? Let me look back over at chat. Y'all know why that's interesting that she's talking about post Hearst or Pool? If I was a teacher, I'd tell you to go find out. But I'm not a teacher, am I? I'm an alleged psychologist, just alleged. That's all. Not confirmed, neither confirmed nor denied, just alleged. Okay. All right. The reason is Hearst is a Hearst versus Florida, and Pool. Those are the two cases I was talking about yesterday, where the Florida Supreme Court flip-flopped on the unanimous nature of the penalty phase for death penalty trials. Florida's different, y'all. They have a mouse with big ears. I'm wondering if, and I don't know the answer to this, but I will find out before Monday, before we go to trial Monday, I will find out. The reason this is important, I think, listening to this prosecutor attorney, I think what they're saying is if the jury instruction moves this particular paragraph, make sure I'm saying this right. If they move the paragraph, she said it's the same exact words, but they want to move it to a different location on the instruction form. I believe that's the defense wants to move it. And the prosecution is saying, no, we're not going to do that, that we don't want that, because at the time that charges were brought, the Hearst was before the court, and you did not have to have a unanimous decision for death penalty. That Hearst was only settled. Am I saying that right? Yes, it was settled afterwards, which would have then made it unanimous. It would have the requirement for a unanimous death penalty verdict. So they're trying to say, I think, and I'm going to go back through and listen close and see if I can work it through. So this is actually really important, and I talked over it. I'm so sorry. So if I'm right about this, then it's possible that right now they're having the argument about jury instructions that would basically free up this jury for a majority verdict rather than a unanimous verdict, that's killer. That would be a killer move. So let's pay close attention and listen. And if I have to go back, I will. But let's see what the judge ends up doing with this, because this is a big damn deal. Just to get a majority that says death penalty, that's a hell of a lot easier to get than a unanimous. Remember Jodi Arias? Jodi Arias is not death penalty because one person said no to the death penalty. So let's listen again and see what they said.
Given the fact that this court has instructed the jury and acquainted them with the terminology 17 times regarding the burden of proof that adheres to mitigating circumstances, and has correctly advised them as to the process, the state strongly objects to any modification, and that's an interesting word, any modification or altering of 7.10, Your Honor. We'd ask that the motion be denied.
Okay, I want a chance to read through the proposed instructions that the defense has submitted and read them side by side with the standard instruction, just so that I can see what's been moved around, and I will have an order for you by tomorrow. Okay, what's next?
Just clarify, is July 19th, we had talked about it, but I don't know that we got it answered if we were in court for trial on
We
July.
did, and all the jurors have been notified to be present on the 19th. And then the 21st, we were going to have a short day and handle the issue with Mr. Zachary Cruz and his lawyer, I think. That's what I had written down.
I'll have to defer to you. I know that I made contact with her and confirmed one of the dates. I just don't have that information from you.
I recall that you gave her two choices.
Yes.
She took the one August.
The
in
7:30 in the
August.
morning date that I said no one would take.
Yeah,
What's that?
I recall seeing that in your email to her,
You just don't know what it is. The August one?
20-something, 21st.
That's okay.
meeting.
I'll look.
All right, so then the schedule for. So the schedule for next week would be the 18th, the 19th, the 20th, the 21st would be AM only, and then the 22nd,
20 seconds all day, Your Honor?
yes.
Judge, you have on the July 14th, Thursday, you had morning court. But we just I want to let you know that that's when we're doing the motion to perpetuate testimony, so we don't have.
That's tomorrow. Thursday, sorry, no, Thursday I had off, like, in other words, not in court.
Right.
Okay, so she wants, okay, here we go. So she isn't going to make a ruling right now, but it's there. We'll have to look it up. But let's think about this, okay? So Hearst versus Florida, they said that a jury has to be unanimous, okay? But in her argument, the prosecutor just said that the charges were filed post Hearst, which would have been under Poole, the Poole versus Florida, that said you don't have to be unanimous. You can be a majority for death penalty. And post is Latin for behind or subsequent to, right? So if it's post Hearst, then it means that the charges were filed when Poole was the standard of law, which would mean you do not need a unanimous opinion. Interesting, yeah? Interesting. I'm gonna pull Poole up again and Florida Supreme Court receipts for major death penalty. Yeah. Must partially receive from hers. We need an attorney, don't we? I'm an alleged psychologist. I'm not an attorney. State of Florida appeals from post-conviction order setting aside Mark Anthony Poole's death sentence. Sentence became final 2015. New penalty phase, finding the sentence to have been imposed in violation of the United States Constitution. Poole suffered no constitutional deprivation in his sentence proceeding. Hurst versus State held that a jury must unanimously find the existence of a statutory aggravating circumstance beyond a reasonable doubt. Yeah, so that's the argument. They're trying to. There's an attorney. Maybe Scott Rice would take this up because Florida. This thing that's happened with Florida and this issue of aggravating circumstances and the unanimous nature of the verdict. This is something Scott Rice should comment on, right? Yeah, I'm going to Monster Blogs. I am. I'm just trying to make sure of what I'm thinking here.
That's fine.
And tomorrow.
She's not going to roll on it today, though.
Expert, I don't recall the person's name, but one of your two experts testifying.
Yes.
What time are we starting tomorrow?
9 o'clock?
Thank you.
Sure.
Judge, may we go on sidebar, please?
Yes.
Okay. Here we go. On January the 12th, 2016, in an 8-1 decision, the U.S. Supreme Court issued an opinion in Hurst versus Florida, where the court struck down an unconstitutional Florida's capital sentencing statute. At the time of the opinion, Florida death penalty law required a jury to make a sentencing recommendation on which only a bare majority of jurors had to agree. They would make a recommendation to the judge, who would then later hold a separate hearing and determine whether sufficient aggravating circumstances existed to justify imposing the death penalty. Under the statute, the jury rendered only an advisory sentence of life or death and did not specify the factual basis for its recommendations. The court held that the judge sentencing requirement violated the Sixth Amendment, which guarantees the right to trial by jury, saying the Sixth Amendment requires a jury, not a judge, to find each fact necessary to impose a sentence of death. A jury's mere recommendation is not enough. Since then, the Florida legislature has twice amended its capital sentencing statute. First, to comply with its reading of the U.S. Supreme Court's decision in Hurst, and second, to comply with the subsequent Florida Supreme Court cases applying that decision. The Florida Supreme Court has also issued several key opinions addressing how the law should be interpreted. These decisions will require resentencing for many, but not all, of the prisoners who were unconstitutionally sentenced to death under Florida's capital sentencing scheme. In March 2016, a revision of the state's capital sentencing statute did not require a unanimous jury recommendation of death. In March 2017, they They amended its capital sentencing law again, this time requiring a unanimous jury determination that aggravating circumstances were sufficient to justify imposing a death sentence, and a unanimous jury recommendation for death sentence before the judge can impose such a sentence. Where are we? In August, this is interesting. In August 10th, 2017, in Hitchcock versus the state, the Florida Supreme Court succinctly rejected the 7 arguments made by Mr. Hitchcock attacking the constitutionality of his 10 jurors to 2 jurors death sentence that had become final before Ring was decided. Rather than explain its decision, the court simply held that these arguments were rejected when it decided, blah, blah, blah. 2 justices disagreed with the court's reasoning, with Justice Lewis concurring. Okay, then what happened? So that's where it stands then. So they're upholding the majority verdict. Okay, so it looks like post Hearst. So it does look like at the time that the charges, I don't see that. Oh, wait. May 2021, there were death penalty decisions. Okay, well. All right, I'm going to let this play for those of you that are still listening. I'm reading, though. I'm not looking at comments. I'm trying to learn here. It's so hard to find anything from this case because they have made so many. No. Jury selection, chaos, and confusion. Yeah, it's been chaos. This whole thing has been chaos and confusion. It's been terrible. All right, so let me find where Judge Scherer issued her ruling on the post Hearst. Okay. Nikolas Cruz. 3 or day 4? Actually, I think we're day 4. Bum, bada, bum, bum. I believe this might be it. Is this it? Okay, so I found, here we go. Let me stop this one and I'm going to try to find where they're talking. When this finishes, I'm going to play yesterday's testimony, which will have Judge Scherer's determination, her ruling on the jury instructions, okay? So I had not planned to do that. I was going to do that tomorrow, but I'm really interested, so I'm going to do it today. So we're going to let this play out till they're finished, and then I'm going to start the second one, okay? I'll be away from the keyboard for about 3 minutes. Monster Blogs. The trial begins on Monday. Opening statements are Monday, July the 18th, which is in 2 days. These are the motions hearings that happened this past week. And so I'm playing the relevant parts as sort of catch up, getting to know who the various players are, understanding what the charges are and the limitations and that kind of thing. So it's just sort of a primer to opening statements on Monday. I hope that answers your question, Monster Blogs. Yes, Snow Lion, we need an attorney, girl. We need your help, please. Help us understand Hearst, Pool, and there's another one. I'll have to get my notes out and remember the other one. Florida had such a flip-flop very quickly on death penalty, capital case sentencing. They went back and forth, so it's confusing. So we could use an attorney. I'm an alleged psychologist, not an attorney.
You do have one back there, it would be that. In the far corner, there's a room that has copy machine. Okay. To the view that he can get from his standing camera, and they showed it to me. In other words, he can zoom in and literally see a pore on somebody's face. They showed me, which is this. Which one did you say was stronger?
This one goes 4 times and they're equal in probably distance.
They did suggest that I can write an order that they're not to film any type of documents. So if you're writing notes, that can't, in other words, there's no, I think you all told me you can't see the written notes that are on their desk.
Not from that angle.
And so I could enter an order saying that they cannot zoom in or attempt to see anything that's on your desk. But as far as the view of you all, it's the same as what that camera can do.
Just get your makeup done, Melissa. Damn it. Okay, just wash your hair, put some nice clothes on, and you don't have to worry about a camera.
That camera there.
The big one.
Yeah, that one is just for the attorneys.
But
And this one is for the podium.
But in other words, they can, in that camera, and they sometimes do, zoom in on you all when you're talking.
They're going to zoom in on the killer. That's what they're going to do, just like they did in Jodi Arias' case.
There's nothing I can do about it at any time, at the state or at the defense. Zoom in on the state or on the defense. So when they showed me the vantage points, I don't see a difference. I know it looks like it's closer.
So, can we look at the vantage point first?
I think so. Would you be willing to show the lawyers so they can see what I saw? What they did was they showed me, they zoomed in with that camera. We had somebody, a gentleman sit here from Court TV, like.
Look
right
at
where you
him.
are.
Ooh, look
And
at
then
him.
they showed me what they could do with that camera as far as doing.
You know what he's thinking right now? He's thinking, this sucks, man. If I had wanted to be an actor, I would have gone to work for Disney. I like this. I'm an attorney. I'm not an actor.
And then what they could do with this, and it was the same view. So even if I were to eliminate that camera, they can still get the same viewpoint as they could with the big camera, if they wanted to. Is my point. So why don't you have a look, and maybe if you see what I see, you'll understand that.
Judge Scherer rocks, doesn't she? She's like a damn rock star. Sincerely.
Does that pick up sound?
We need t-shirts with Judge Scherer on it.
What is inflation?
So, I'm gonna do that now.
We'll take a recess and you all can go have a look, okay?
Okay, thank you.
Sure.
Man. Melissa, hush.
Yes,
Okay,
I'm gonna sit here though,
no, that's
because
fine.
I'm just doing some busy work.
He's the TV, the court TV guy. That defense attorney was like, man, this sucks so bad. Everybody's going to know what I look like. Yeah, Nicholas, you got your 5 minutes of fame, big guy. Jerk.
Thank you.
These are all, there's agreed upon.
Can I make an observation here?
Sit in that chair.
Poor guy. Can I make I'm going to make an observation here. They're in Florida. It's the internet. It's the entertainment capital of the South, right? Disney, MGM. It's all there. Of course, they want great cameras. Of course, they've worked out the various angles of the cameras. Of course, this is going to be a production, people. This is going to be a damn circus, unlike anything the Johnny Depp stuff had. That whole Amber Heard crap, no. This is going to be a big deal. As it should be. I mean, you got 34 families that were directly affected by this little jerk. It's interesting, the difference in perspective. You can see really how big that area is where they're trying the case, as opposed to where the seating is. It looks really small from the back of the room. Dare I say it, prosecutor, you look marvelous. Nice tie, too. Good color. He's going, okay, zoom in on my buttocks. That's what I think of you people in the defense table. Blue moon. I shouldn't sing with my voice froggy. She's a great attorney. I love her. And then home without a dream in my heart. Isn't that a pretty color tie? Violet, yeah? Is it violet? It's lovely. You look marvelous. I really think they're probably about done today. Don't you guys think? Let's see. I got one more.
Okay.
Are you happy, Melissa?
Placement of that camera up there. That camera can capture all of the angles, and I understand that they want to be able to move in closer to the Wiggins. but that's for the benefit of the public. And I think that it creates an obstruction for the defense because
No.
we have to be
No, it doesn't.
picking up pieces of paper and covering our face.
No, no,
and
no.
talking to co-counsel.
No,
Also,
you're wrong.
conversations with our clients. If the court is not in agreement to move the camera, then we would ask that, and I can fashion an order. What's it? It's on a robot. It's a robot, so they moved it to show us.
Oh, it was directed like that before. Okay.
If the court would fashion an order that the media is not to videotape any conversations between any member of the defense team and Mr. Cruz, or any conversation between Mr. Cruz and the defense team. And additionally, we would ask that there be no video of the conversation between the attorneys on this team.
She's not going to do it.
I just don't know how I would do that.
There you go, girl. Stand your ground, Sharer.
You guys are pretty much talking the whole time. So what we're telling the members video,
Unless we're engaged in conversation amongst ourselves,
right?
or if we're engaged in conversation with our client, which is attorney-client privilege, then
Sure.
we would ask that they don't videotape. Because we believe that, it shouldn't interfere with the administration of justice or the procedure before the court. And I'm telling you that it might, because we're gonna be constantly trying to pick up something to cover our face, and I can tell you that
Why? The public can't affect you or the jury.
Lips and then televised.
What are you talking about, lady?
Position of a member of this team. We're aware that that has happened, and we just want to be mindful that we're able to focus on what we're doing as attorneys and not all these cameras in court.
I understand. I just.
Come on, Melissa. You know you can multitask, girl.
Whether or not, I don't know that I have the ability to tell them not to take photographs of certain parts of the courtroom.
I think that the administrative order gives the chief judge and the trial judge discretion as to the amount of cameras, the placement of the cameras, and what can be videotaped.
Come on, Lizzie. Stand your ground, girl.
And I do believe that, the courtroom and the media would have a right to be heard on this if
Yeah.
got curtailing their rights.
I concur. I concur.
What they can take photographs of. I mean, nobody wants to have their notes photographed. The state doesn't want to have anything on our table, and we're certainly in a more vulnerable position from a camera coming from behind.
You certainly are.
They may want to be heard on this issue as well.
Did you see what I was talking about though, that large camera, if he wants to, he can zoom in as close as this can.
Yes, and that kind of exacerbated my concerns. I didn't realize, like when you said pour on your face, you were right.
They don't, I don't think.
It's Melissa is worried about the pores on her face, people. Okay?
But,
Defense attorneys are people too.
but
Can
you
we
saw what
remember
I'm
that,
saying?
please?
So you're suggesting that I order.
The court reporter smiling.
How can I refer to that
Media.
large camera? No, that big camera,
The big one, back there, let's call it the
main camera.
behemoth.
Are you suggesting that
I think we
wear
should name the
main
camera the
not
behemoth.
Not to video the defense table also, or are you just talking about this one?
Well, I'm in objection to this
Okay.
camera, the one that's right in front of me and in front of you. I believe that the main camera covers everything that camera covers, and it's unnecessary. That's one, and then I would ask for a court order to prohibit the media from videotaping our conversations between counsel and our client, and then conversations between each other. Each other meaning the defense.
Okay, so Ms. McElroy's not here. I have to give her the opportunity to be heard, but the media, the cameramen were nice enough to suggest some alternatives or to pose some language, prohibited language that could be used by the court. In other words, they can, okay, I don't know a lot about technology, obviously.
Never
But,
admit it, Sharer. Never admit what you don't know, Elizabeth. Never. Never do that.
That I can tell them, don't zoom in past this point. In other words, they're able to say, this is, I forget what they called it, frame or.
The point of no return.
That I can say, don't go past this point. So that's a consideration, and then, they're also able to limit, videoing the documents that are on the table, so that you don't have to worry about your notes being videoed.
Look at the court reporter. She's lovely too. Can we admit that? She's beautiful as
I'll
well.
have to ask Mr. Cameraman to clarify if I'm wrong.
Mr.
Although there's
Cameraman.
in the courtroom, when
Please,
footage is
Mr.
sent to
Cameraman.
wherever they are, they can manipulate the photo and make them different. So he could have a preset in the courtroom, but when he sends the feed, is that correct?
But that's, go ahead. That's correct on any level.
Please, Mr. Cameraman, look and see. Is there a pour on me? When you zoom in so close, can you see it? I should
Mrs. McElroy, and then
wash
look
most.
at the-
Mr. Cameraman, do 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 do. Do, 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 do.
Access versus his due process rights.
Yes,
Okay, how long do you think you're?
Judge Scherer just got triggered.
The whole day, or? I'm just.
I'm not sure. I was surprised that we're all there. I mean, it's only just one issue, so, I would hope that it wouldn't be much more than a half a day.
Be more definitive there, sir.
So if we start at 9 tomorrow, if I, set this issue, we could, I don't know if it's easier to set Ms. McElroy for like 11:30.
Oh my God. I'm going to end this now because now they're just doing scheduling and that makes me a crazy person. Okay, so now we want to go to the following day. So I shall stop this. And now we're going to go to the day 4 of Florida versus Nikolas Cruz motions hearing. And the reason that I want to do that is because she is going to rule on the jury instruction change where they're moving a paragraph to the next. Hold on, let me find it. Is this it? Yes, this is it right here. Is that correct? Am I on the right thing? Let me double check. Day 4. And yes, that is the day 4 hearing. That's what we're looking for. All right. She can be taught. And I think let's see where we want to start here.
Have prepared on the proposed jury instructions.
Here we go.
Sorry.
That's okay. I have an order on the jury instruction motion from yesterday. We're making copies of it now to hand out.
Thank you, because that's what we're here for, Judge.
Other than, I know, I have a blank. Miss, no,
McElroy.
thank you. Miss McElroy is here. Somebody must have told you that we were going to be off schedule. So other than hearing from Miss McElroy, is there any other miscellaneous?
I do have a miscellaneous, but
I was just gonna tell you, this is Kelsey Nolda from our office. I think you've met her before, so you can recognize her. She's just helping us. Yeah. Okay. Good morning, Judge.
Good morning.
just, again, miscellaneous matter, that we had indicated on this.
I will do that, Daves.
The swastikas on the magazine that we weren't gonna use it in our case in chief, and, but
It was
it has to be covered.
for rebuttal.
Introduce the evidence, and we can put, just well.
Well, I think I gave Ms. Curtis until this Friday to file her, if she wanted to do a written closing.
You're right.
So.
Oh my God, Melissa, really?
I forgot about that.
Please, thank you.
Is that all right with the defense that you put stickers on it for case in chief? On
Like
both
a red
sides?
sticker or just a black sticker? We'll show it.
Probably like a label, white sticker to put on, a large label, just to cover it.
I don't have a problem with that.
Okay, thank you. We'll show you for it.
Okay, thank you.
That's it?
The judge is like, amazing.
Roy, come on up.
Come on, Miss McElroy. Miss McElroy's been trying to be heard for 4 days.
I was supposed to be at 11:30, but I appreciate you. I will be here and available if need be. I was able to speak with the defense and the state, and we have resolved the defense objection.
Okay.
With the court's approval, of
Sure.
course. I don't know if Ms. McNeil, you'd like to, can you tell her what we've agreed to?
Sure, go ahead.
Okay, so what we've generally agreed to, and if I may, Your Honor, I need to look at
Sure.
notes, because we just this morning went through it. And Adam, if I get this wrong, or anybody in the media, let me know. We've agreed that this camera, which is camera number 2,
Okay.
will remain in the courtroom, but that will always shoot wide, as
Okay.
wide as it can shoot. So it won't zoom.
Okay.
Also, this camera will remain, but it won't go in any tighter than this camera number 2. So that's number 3, this is number 2.
Okay.
So it will not be zooming on the defense table any closer or tighter than that one can do.
Okay.
Also, we already know that during recesses, these cameras are not supposed to be, on. They might be on a seal or in the ceiling, but they're not supposed to be recording or broadcasting. That's correct, right?
I had spoken to the camera guys, and I should have brought this up, but as long as there's no audio, Court TV had asked me if they could do just a wide angle view of the entire courtroom. In other words, not zooming in on anything, just showing what's going on.
Like they did in the Johnny Depp trial.
During the recess?
Yes, and that is fine with me. What I don't want is to me, what's important is the sound. Because we've had the opposite problem where there's no picture, but there is sound, and then people think that they have privacy and they talk amongst one another, including myself, and then we don't want that type of thing broadcasted. But as far as just a wide shot from behind, I think I spoke to Adam about this last week in Court TV, and I don't have a problem with that.
Thank you, Anna. And then, Liz, did I miss anything?
One other thing, Judge, we've come to an agreement that if we need to speak with our client or co-counsel, then we will say, may we have a moment to speak with our client, or may we have a moment to speak with co-counsel, and that will signal to the camera people to go wide.
If it's during the proceeding,
Right.
because we know that during recess, we won't be, focusing in on them, and there'll be no audio. There's never any audio of conversations between them.
Right, they showed me yesterday. As long as that's your deal, I mean, I don't know if I'm gonna remember. I mean, I think I probably will remember after 4 or 5 times, but as long as you've made that arrangement with the media and you're not gonna be looking upon me to enforce that right away.
Understood.
In other words, if they're not doing it, you're gonna have to go sidebar and remind me what it is that you've agreed to, okay?
Yes.
And just generally on that, we understand that things may have come up during the course of the proceedings and unintentionally, and we're certainly, obviously, would like the court to know that we will be available if the court has any concerns or the parties have concerns to, I'll be available the entire time, and of course, the media representatives as well, so if anything happens and there are concerns.
Okay.
Your Honor, the
Yes.
state would request that the same protocols apply to
filming of the state's table with regard to the cameras.
So, meaning well, if it's gonna be a wide lens,
Right, but
gonna
no zooming. We're not gonna be conferring with a client, but if we're, speaking to each other, we won't be signaling to cut. But just the same considerations that there's no zooming on us, that it be kept wide.
I mean, if it's wide, if it's gonna be kept wide in general, I don't think you can zoom for one half and not the other. can you?
Correct.
Okay.
That's correct. And so, but it's, I'm glad you raised that. And my understanding is those are uniform restrictions on both cameras
Okay.
that are pointed at you. And in fact, there is the back, so that's different.
All right, thank
So
you.
the view, Adam, that's gonna be on is what you showed me yesterday, the medium zoom, because to me that was,
So on the camera in front of you, it'll be as wide as it can go.
so it's not what you showed me yesterday.
It'll be wider.
Okay,
And so we have agreed that it can pan left and right, at least have movement functionally, change from one desk to the other, but not zooming in on that camera.
okay,
On that camera, it's a little different, because we were zooming into a medium point, which was no greater than the camera 2 for the defense table. I didn't speak about the prosecution table, so I don't, it has a zoom function, because we're gonna be zooming into the gallery with families and everything else. So it does have to have some zoom function.
if they keep it to what they showed me as a medium, you said it's a medium,
It could be like a medium shot, maybe 3 of them sitting at a table.
it's not invasive. We had the sheriff's office sit at this table yesterday, they put it on the medium Zoom, they were talking, and you can't, first of all, you can't hear them, and you can't tell what they're saying.
Okay.
In my opinion, if you all want to have him put it on that setting and go take a look.
Wow. We already did this, didn't we, Judge?
I thought that the whatever they.
Why are we doing this again? You're the judge. Make a ruling. This is not new. We have been watching trials for years now, 10 years. You want to be able to see the witnesses, right? When they're testifying, correct? This is so ridiculous. That looks perfectly normal. That looks like that's what we saw in the Travis Alexander, Jodi Arias thing. It's just silly. I guess you guys can tell I'm irritated, right? It's foolish. They're games. Melissa's ridiculous. She's a ridiculous human being. And I'm going to tell you, I see a problem right now. You see the jury box?
I think everybody has.
You see the jury box? There's a problem. There's a way right there to get in trouble in terms of getting your,
Thank you.
man. You can't use that camera. Don't underestimate Melissa. I can tell you that right now. She wants this angle. She wants them to accidentally capture the face of a juror. Mark my words. Don't trust Melissa. Wow. You see right there, you got the corner of the jury box up on the screen. That's not going to work. They can't have that wide angle on it. Melissa, keep your nose out of things you don't understand. You don't know anything about Hollywood. Let the camera people figure out what to do. Don't you tell them how to do their job. This is crazy. This is crazy. She is so obstructionist.
Nicole is out, so you all have my
my email,
Yeah.
my direct email. Don't feel bad, just loop me in, because I'm sure she'll be checking and monitoring, but I'm not sure how ill.
That's
she
it.
is.
That was the whole day yesterday.
So,
Okay, we maybe, and we'll send it to Nat, I just sent to the state a proposed order for one of our doctors, Dr. Connor, but I know Nicole usually handles those, so I'm still gonna try to do that. But if they agree to it, then we will be sending that to you for signature, so I'll send it to that email address. Didn't hear? I was saying that we're gonna be probably sending her that proposed order, I just sent it to you guys, even though normally Nicole does it, the order from Dr. Connor. I just sent a proposed order that you need to look at, and if you're okay with it.
do you want to do a team huddle? It just reminded me of, never mind. Okay, have a nice day.
That was a monumental waste of time. Literally a horrible waste of time. Okay. Well, there you have it, right?
I have an order on the jury instruction motion from yesterday. We're making copies of it now to hand out. Are there any other miscellaneous matters other than, I know,
Okay. Hold on. I'm trying to find my page. Got all this stupid case law up that I'm not qualified to read. Well, I mean, I can read it. Doesn't mean I understand it. Okay. So that was a monumental waste of time, and I apologize. We're going to have to find the order, and ultimately we can see what they determine. Now then, I want to talk about Brenda Woodard. Brenda Woodard is the 62-year-old mother, biological mother of Nikolas Cruz. She is now dead. She recently died of cancer. Now, she gave up her two children, Zachary and Nicholas, to adoption in the days after Nicholas was born. So he was a baby when he was adopted by Roger Cruz and his wife. So it says regarding Brenda Woodard, the extensive criminal and drug abuse history of Nikolas Cruz's biological mother will be a factor in whether he is sentenced to die for the massacre of 17 people. The mother played no role in Cruz's history, upbringing. She gave him up for adoption in the days after he was born. Her past, however, included crack cocaine use while she was pregnant with Nikolas Cruz. So we know that there's been testing for fetal alcohol damage, but they know that there was an arrest during her late pregnancy for crack cocaine. She was purchasing crack cocaine, clearly under the influence and using. So it's a fact she was using alcohol to the point that genetically he was affected by the alcohol use, and she was using crack cocaine. It is not necessarily her past that is important here, but how her past contributed to his genetic makeup. Her use of drugs and alcohol while pregnant with him and her genetic proclivities were passed on to him. It might not carry the day, but it may give the jurors another mitigating factor to consider. The identity of Woodard was confirmed by the Associated Press. The American Bar Association for Defense Lawyers in Death Penalty case say they should closely examine all of the defendant's past family. They're talking about genetic family, going back 3 generations. Pinellas County Sheriff Bob Gualtieri who was the chairman of the State Commission on Investigating the Shooting, separate from the prosecution, said Wednesday that all of Cruz's background is relevant. That's nature versus nurture, right? So the nurture part from Mr. and Mrs. Cruz, and then the nature being from Brenda Woodard. If information has come to light about his biological mother and there's some relevance there, we will take a look. We're looking heavily at his background, his whole background. Cruz is charged with 17 counts of murder and attempted murder, and another 17 counts of attempted murder at Marjorie Stoneman Douglas. Lawyers said he will plead guilty if they spare the death penalty. Prosecutors have refused that offer, and it is notable that he did, in fact, plead guilty. Broward County Public Defender Finkelstein declined Wednesday to discuss how Woodard's past might become part of the case, but he repeated, Cruz is ready to end it now. Cruz wants it over with. He wants the death penalty. Finkelstein said, lock him up forever. Throw away the key. Never speak his name again. Maybe it'll curtail some of the pain and hurt that will certainly happen if this case continues into a decades-long march toward death. If the case goes to the death penalty phase, all 12 jurors must agree on capital punishment, or Cruz will get an automatic life prison sentence. Cruz and that's up for debate. The scholars are still debating that point. Cruz and Zachary were both adopted by Roger and Linda Cruz days after Woodard gave birth to them. Roger died when Nikolas Cruz was a young child. I believe he was 6. Linda Cruz died in 2019, November 2019, I think. Just a few months before, no, 2000. She would have died November 2017. 3 months later, February 2018, were the shootings. So his mother died 3 months before the shootings. That will be brought up on mitigation. Nikolas Cruz has numerous behavioral and learning problems throughout his life, along with fascination with guns and his own problems with alcohol and drug abuse. Court and prison records show that Woodard was arrested more than 24 times from the 1980s through the 2000s for crimes that included drug offenses, car theft, weapons possession, burglary, domestic violence, and battery charges. She served a variety of prison sentences over many decades, including one 18-month stretch for car theft and fleeing. Well, it's actually assault of a law enforcement officer and fleeing an arrest. Woodard was charged in 2010 with using a tire iron to beat a person that she shared an apartment with in a senior living complex. Nice lady, huh? Her last arrest was in 2011. Woodard did not immediately respond Wednesday to a message left on her cell phone. See, that suggests a real problem with the amygdala, which you would see like in a case of a biological psychopath. And I've said, Cruz looks empty. His eyes look like a shark or a snake's eyes. There's no emotion going on in there. Cruz's half-sister and Woodard's daughter, Danielle Woodard, has had her own extensive brushes with the law and is imprisoned as a habitual offender. Her most recent convictions, this is Nikolas Cruz's sister, is attempted second-degree murder, cocaine possession, battery on a law enforcement officer, and credit card fraud. She was scheduled for release in 2020. So it's important to know that what I'm reading right now is about his genetic family, not his adoptive family. So I know BBT and Rabid Dog, a couple other people, they enjoy that discussion about, nature versus nurture. And this is a really clear case of where the nature part seems to be more influential on the murderer than the nurture part. For all intent purposes, he grew up in an upper middle class family, plenty of money, mom and dad present until about the age of 6. mom was supportive and loving. She doted on the boys, treated them well. So took them to counseling and therapy. But if the underlying genetics are profoundly disrupted, like I said, in the case of a biological psychopath, if the corrective emotion isn't there, it just isn't there. So it doesn't matter what kind of environment you put them in, right? Yeah, this is really and truly one of the most interesting cases when you get into the details. It's one of the most interesting cases really since, I guess probably Chris Watts, really. So, okay, that's it for today. How is that? I can feel my Tylenol wearing off. So I'm fixing to go take some more Tylenol and I don't know what else. Hey, Gracie, welcome. I hate how he sits there dressed in normal clothes. Like he's one of the guys. He should be in a cage in a jumpsuit. He should be shackled, Gracie. And I don't say that in a punitive way. I mean, with his history, his 4 years in the jail, and the impulsive violence, multiple episodes of impulsive violence against other people other kids in the jail and against guards. He should be in shackles. There's no way of knowing when he will twist off. And I believe, it's my opinion, I believe that's why they've got that massive attorney that sits right next to him. I think it's his job to grab him if he jumps, if he leaps. Cruz has the typical dead black eyes of a psychopath, right? It is one for the book, Snickers. It's not only interesting from a true crime perspective, it's just an interesting story. Psychologically, it opens up for a great deal of debate in the same way that the Chris Watts case did. And then from the view of, how do we stop these school shootings, the school shooters? How do we identify them early before they act? And then how do we help them? Ultimately, the answer could be in all of those school records. So for people that are in forensic psychology, this is a gold mine. It's a gold mine of information. Yeah. Where did you hear about him with other kids in jail? Not now. Not now, but he did initially. He just, they would be in a common area and he would just explode and attack. I'd want to keep him alive for study purposes. I don't think they will. I think he's going to get the death penalty, Snickers. They're going to have a hard time coming up with mitigation, I believe. And can I say this? At the beginning of this video, I went through the jury, 7 men, 5 women, and what their jobs were, what their background and training were. And there's a lot of them that are either police or military. It's going to be they're not going to be moved by emotion. They're not going to be moved by emotion. If the music lover who works at a family business, if the music lover is young or female, it's not likely that she will or he will stand as the one person against the death penalty. If the person that is against the death penalty is one of the older people, male, or one of the military or police, then they will stand firm against the other 11. So it's going to be interesting to watch. I find it fascinating that over the last 50 years, homicide on the whole is down, but school shootings have been on an increase. It's crazy, right? Greetings, Mercedes Fuller. They could not construct Sandy Hook or Columbine since they were dead. I think the death penalty is the easy way out. Make example of these killers instead of letting them die because that's what the school shooter is expecting. They're not expecting life in prison, though. Yeah, you could be right. I think that was another interesting thing about Nikolas Cruz, about his psychology. They all these shooters, they're suicidal. Would you agree? When they go into this whole school shooting event, they're suicidal. They go in leaving manifesto or letters saying, all that's wrong in life and why they don't want to live and whatnot. But that's not what Cruz did. He executed a plan that got him into a building, completed its objective, got him out of the building without anybody suspecting him. He literally walked out with the other students. If he had not left the gun behind, they would never have known that it was him. Maybe they would have been able to identify him with the cameras, but the cameras, his face was obscured. So he didn't plan to die. It's very, very strange. So that'll be another, keeping him alive gives you access to what he was thinking and doing during those plans, right? By pleading guilty, that sort of removed them from the ability to get his story. But if you could keep him alive, if he gets the life without possibility of parole, then you have Then you have an opportunity to go in and question him. He probably won't talk. He doesn't seem to be interested in explaining himself. He had a girlfriend for a while, which is really crazy that he's conversing by written letter, to a girl, a young person that, I don't know. I mean, it's like a love affair when you read the letters. It's weird. They are suicidal, so it's teaching other killers to do the same. If they see Cruz is going to die, you go into school shooting as the shooter knowing you're going to die. It's an easy way to die. Yeah, death by police is a thing, right, Mercedes? It is. Yeah, so I'm not gung ho pro or con death penalty either direction. I do think it's important to say that the families of the 17 that were killed, they are all on record. They want the death penalty. And I think their choice, their opinions have merit in my opinion. And Cruz said that he wanted his fate determined by the families, knowing that the families want death. So Cruz himself, he's already given up. He doesn't want to die. And so what Mercedes is saying is, if we really want to punish him, don't we want to put him in federal penitentiary for the rest of his life, right? Yeah. So I can see both ways. I wouldn't be freaked out either way, for or against it. I can see either way going. Exactly, Caroline. Yeah. So the families are on record. They want the death penalty. Cruz is saying he wants the families to choose because he knows they want the death penalty. And you have to think, did Cruz expect to be shot? Was he surprised that he got out of the building? So that would be another question I would have for him. Did you do this believing that they would kill you before you got out? Absolutely, Mercedes. It's good points. Okay, everybody, my throat hurts, so I'm going to go ahead and end this live. I sure do appreciate all of you spending your Saturday hanging out with me. Not always very exciting to watch trial motions, but definitely preparing for Monday. The trial starts Monday in 2 days and 9 a.m. And so it's going on in Fort Lauderdale, Florida. And all of the news is in town. They're all gearing up. It's going to be a big thing. So. Yeah, let's see. I think the emotional side of the parents want death for their peace. And I don't think I don't think that we have a right to be dismissive of that need for peace, considering the trauma and the grief that they've experienced, right? Um, at some point, healing has to begin when you're dealing with that level of trauma. It's very difficult. We know this from other cases. It's very difficult for the family members to find resolution and then begin to rebuild a new normal. It's really difficult as long as there are never ending hearings and motions and stories, uh, basically for the next 10 years being on the edge of your seat, not knowing if the case is going to get overturned. It's very difficult to move on. If the person gets the death penalty, then there's a bit of resolution. So I would not deny the parents their right to peace. I would not deny them that at all. Yeah, there's a lot going on. Kristen Smart's trial, it's also starting on Monday. Amber Heard finally, I think, has been shut down. I think Depp has finally got his. Sorry, I'm yawning. They won't answer. It's all lies, Mercedes. If you look at what happened with the Chris Watts case, are you familiar with Chris Watts? Do you know that case? Uh, he has given 5 different versions of what happened the night of the death of his family. 5 different versions. So each new version is additional trauma. So the family members, whether it's Cindy and Ronnie Watts or whether it's the Rucheks, each new version is another murder of their loved ones. I mean, we've got little Bella being murdered in her bed. She was murdered twice, once in her bed, once in the bedroom. She was alive in the car with her dead mother on the way to the location. She was murdered at the location after watching the murder of her sister Cece. I mean, how can a grandparent or an aunt or an uncle, how can they tolerate the ongoing torture? It's emotional torture. So I disagree. Keeping them alive to get the story, They just change the story according to what they need. That's all. This guy shot 34 people, killed 17 of them. He's not going to be moved, by emotion. He's not going to give a damn about family members' questions. He's not. What is that? Oh, wait. Sarah Boone. Oh, Rabid. Really? Man, there's one, guys. There's a trial that is going to be crazy. So if you have not heard of Sarah Boone, she and her boyfriend were drunk, and she zipped up her boyfriend in a suitcase, and I mean anyway, he died in the suitcase. So so go to Rabid Dog's channel. Rabid, put your link so everybody can find the videos that you did on the Sarah Boone case. You guys need to go and watch that in preparation of the Sarah Boone trial coming up, because that woman is a trip. She is a very interesting person. Absolutely. So, golly, we're true crime community is going to be hopping this next month, right? It's going to be crazy. Off the hook. Aren't you a mod, Rabbit? You're supposed to be a mod. I made you a moderator. Let me go to my YouTube channel. Hold on. Oh my God, I feel so bad. Ugh. I feel horrible. Okay, where do I want to go? I want to go to my channel. I want to go to my live. Okay. And I want to, I'm going to mute. I'm getting there. Hang tight, and I'll have the link and everything for I'll have the link for Sarah Boone that Rabbit did. And then I also got to make sure that I yep, that's the real Rabbit. Okay, so here's the link. Okay, here's the link to Rabid Dog's channel, and he did these great series on Sarah Boone, and she's a trip. Definitely worth going. And now I got to go back into my YouTube channel so that I can mod. I sure thought I had you as a moderator, Rabbit. Let me see what happened. If you don't mind, would you guys please give me a thumbs up? I'm trying to make friends with the YouTube algorithm. In fact, I want me and the algorithm to be besties. And the only way that can happen is with some thumbs up and some comments that are left. There we go, Rabid Dog. Okay. And comments that are left under the video. Those things are really, really super helpful. You don't have to do super chats. You don't have to do all that. All you got to do is just hit the little thumbs up and then leave some kind of little comment under the video. And that will say, hey, algorithm, Jules really wants to be your friend. Okay. So if you guys could help me out with that, I'd sure be tickled to death. Okay. I think that did it, Rabbit Dog. Can you share a link now, Rabbit? All right. So we got Nikolas Cruz coming up Monday, opening statements on Monday. It's a penalty phase for death penalty. We got Kristen Smart, and then we've got a week from Monday, Sarah Boone's trial. And hers is a culpability. It's actual trial for guilt or innocence. Is it murder? Did they charge her murder, Rabbit Dog? Or was it second degree? But she's pretty freaky. She seemed to be quite emotionally detached too. Second degree. That's what I thought. Okay, good. Okay, so a week from Monday is Sarah Boone's second degree murder and its guilt innocence phase. And Monday, in 2 days, we start Nikolas Cruz, who has pled guilty, and now it's a death penalty, capital punishment determination phase. Lots going on in true crime. Yeah. I'm thinking I need to take a week of vacation. I may need to take a week of sick leave if I don't feel better. I'm feeling terrible. All right, peeps. I'm going to get off the computer because I do really and truly feel bad. I don't often complain about it, but I'm not feeling good at all. I hope you guys have a wonderful Saturday. I will be watching to see who goes live with some of these discussions. So far, I haven't seen another YouTuber that's talking about Nikolas Cruz. And we have Rabid Dog doing Sarah Boone. And who's doing Kristen Smart? Do we know yet who's doing Kristen Smart? Anybody? Thank you, Snickers. I appreciate that. Okay, people, let's see where we stand here. I got to go over here. I got to go here. And I got to go here. And I got to go here. And then I've got to press mute. We have 43 watching and 68 thumbs up. Hell yeah. Killing the algorithm, baby. We are killing it. Bigger in Dallas. So if you have not hit the thumbs up, I invite you to do so now, please. Rabbit is still not a mod? He should be. I just added him. I'm looking at it. It says he's been modded. Weird. Let's see. Rabbit. Go to channel. Videos. Because that's not the real Rabid Dog. Oh, well, joke's on you, troll, because I went by the real Rabid Dog's channel to mod him. So good luck with that, Emily. Didn't work this time, did it? Okay, that's so funny. All right. You guys have a great day. It's okay, hybrid. It's not the real Rabbit. Oh, he's on his backup account right now. My main account was blocked by accident. Was blocked by me, by my channel? You're not blocked. You're a mod. I'm talking about your main channel. Oh my God. Problems. Drama. Let me look. I'm looking. Hold on. Let me see what's going on here. Damn it, my throat hurts so bad. Oh, shit. Also, if you're not subscribed, as I said, I'm making friends with the algorithm, and the algorithm really likes it. When you visit a video and you like it, you should go ahead and subscribe, because that tells YouTube that people like it and they share it with more people. So if you haven't subscribed, would you please do that? I know it's annoying and childish and YouTube-y, but you know, what can I say? I'm pandering. We're the best damn community on YouTube. Did you guys know that? We're the best community on YouTube, and that means you should subscribe lest you miss all the cool, fun things that are happening. Yeah, Rabbit Dog, you are a moderator. Okay, so let's go to blocked channels. Still looking. I wonder why this person's blocked. Should I unblock that one? You are not blocked. So 315, let's see. No. Maybe through the Google account. I'll go, wow, my head is hurting so bad. No, you are not blocked in my YouTube account. Not blocked there. Okay. URL, okay. So I'll have to go rapid. I'm going to go ahead and save. Okay, Rabbit, in order to check my block list for Google, I'm gonna have to well, I don't know if I can see it though through YouTube. Let me look at my YouTube. I still think you're a troll. I still don't think you're the real Rabbit. Oh, now you're a moderator. Okay, so it worked. Okay. All right. Okay, everybody. You guys have a great Okay, we're good, Rabbit. Okay, I was double checking it. Okay. All right, peeps. I appreciate you guys so much. I appreciate y'all so much. And if you haven't subscribed, I hope you will, just to help out, to try to get my videos shared a bit. And we will see how things go on Monday on the trial. Okay. Thanks again. Y'all have a good Saturday. All right. Okay. Bye.